Welcome to Looking at Legal Stuff. Today we have 10 hearings in the divorce of a couple where Mom claims she had to flee from the home after she was unable to tolerate any more of the abusive power and control that her ex-husband forced on her, including having to be a sex slave for him. She says he wouldn't allow her to work while they were together because she was expected to always be available to him. She claims he drinks excessively, has a dangerous driving record, and has never helped with the children. She says now that there's a court case, he's pretending to be this amazing hands-on dad, but that still hasn't stopped him from continuing to bully and harass her relentlessly about reconciling until she recently applied for a protection order. She says all she wants now is the return of her and her children's possessions that she says she left behind. Dad and his lawyer spend the better part of a year promising to return her items, and his lawyer claims that Dad has set the things aside to be exchanged. But once his lawyer withdraws and he has to answer to the court directly, his story changes dramatically. He tries all sorts of antics with the judge, including lots of guilt trips and snarky comments. So what does the judge think of his antics? Let's find out.
Next matter I have is the Luciano Torres and Melissa Wolski matter, 233442-08. There we have Mr. Foley representing Mr. Torres. Mr. Foley's present. I can see him.
Good.
And Ms. Wolski, are you on the line?
Yes, Your Honor.
Okay, there you are. I see you. Welcome to both of you.
Good morning, Your Honor.
Good morning. We're on today for the motion brought by Mr. Torres, represented by Mr. Foley, sorry. I saw proposed orders filed by both Mr. Foley and also by Ms. Wolski. And so if there's any preliminary issues, we can hear those. Otherwise, I'll hear from Mr. Foley.
Thank you, Your Honor. I think my client pretty much laid out his position in his declaration. This was a 4-year relationship resulting in the birth of one child, Mason, who is 2 years old. My client, as indicated in his materials, worked from home and continues to work remotely. He's currently holding down 2 jobs, one with the state of Washington, where he is a senior systems administrator. He's actually the acting supervisor, and then a second job at a company called SSI, where his title is senior Microsoft systems engineer. That second job, as the court can see, the parties had significant financial issues, and so the second job is primarily to pay down debt. So
Can I ask a question related to that, Mr. Foley?
Sure.
I saw pay stubs from L&I. Did I receive any information related to the SSI?
No, Your Honor. And actually, I did not learn about the second job until actually this morning. So I'm just passing that on. And my client is on the line if the court at the end has any questions. So, but essentially, Your Honor, the party shared in the care actually of 2 children. The boy Jackson was Miss Wolski's from a prior relationship, but my client treated him, just like a biological son, and then Mason, the 2-year-old, and again, both parents were essentially stay-at-home parents, although my client did work remotely. There's been some pretty severe, scurrilous allegations made against my client. The materials that Mrs. submitted, it was difficult for me to tell what was responsive to our motion and what constituted an answer to the petition. But all that aside, Your Honor, we were before Judge Warning last week on Miss Wolski's petition for a protection order, and essentially the same information was presented to Judge Warning, and he entered a 90-day order in favor of Miss Wolski, but refused to restrain my client from having contact with Mason. And so, as you can see from our petition and our request for temporary orders, we're asking for designation as the primary custodial parent. Miss Wolski, we are asking that she have visitation, essentially local rule, every other weekend, Friday to Sunday, and then a Wednesday night dinner night. One thing I do want to point out in her materials, Your Honor, and unfortunately they're not broken down by page number or Bates stamped, but you can see there's a page where my client is texting Miss Wolski, and she began at, I guess, October 22nd, and he sends her a text each day. When can I see my kids? They miss me. When can I see my kids? And there's basically no response from Miss Wolski. One significant factor, and I think Judge Warning kind of seized on this, there were a series of text exchanges between my client and Miss Wolski leading up to October 18th. They had celebrated an anniversary dinner at Long Beach back in September, September the 13th. The kids joined them. They went to Walmart, bought Halloween costumes, and there were photos of the kids, Mr. Torres and Miss Wolski at the apartment that my client had arranged for Miss Wolski to have. So the text messages in the run up to the 18th were certainly indicative of two parents co-parenting who had a good, working relationship. As a matter of fact, in July of this year, they took essentially a 30-day road trip to visit his relatives in Texas. And one of the things I told Judge Warning, the difficulty in the case was reconciling these texts with the allegations that Miss Wolski has been making. But in any event, the last text sent by my client on October 18th was around 2:13 p.m., basically arranging for dinner that night. They were going to get together and go have pizza. I think that's what the plan was. Miss Wolski was served later that afternoon at 3 o'clock, and then the next day up pops this protection order, and then complete blackout of communication with my client. And my client has not seen his child since then. And even before then, as you can see from the texts, his contact was severely limited without any real explanation by Miss Wolski. So it's unfortunate that the protection order strategy was used the way it was used, and I'm sure the court's seen it a million times. It definitely was a strategic play by Miss Wolski, completely unsubstantiated. So, our position is, this information, all of this texting, it's all self-serving. None of it is supportive of the allegations that she's making. My client has been stably employed, has risen to the ranks of supervisor with the state. He's certainly doing the best he can to support his family, but he would like to have contact with his child. And we believe designating him as the primary custodial parent is the proper thing to do, given the judgment that's been exercised by Miss Wolski. So our request for today is that he be designated the custodial. Miss Wolski receive local rule visitation. I did note in her materials that she evidently, I think, is working 2 jobs, although I didn't see a financial declaration or any type of financial analysis. So I don't know that we can really move forward today on the issue of child support, but that's our request for today. Thank you, Your Honor.
All right. Thank you, Mr. Foley. All right, Ms. Wolski.
Yes, I have a few things I want to address about this apartment Luciano has claimed to co-sign for me, and this beach restaurant date that he is claiming. None of those things are accurate. I met up with him on the 13th of October, which happened to be our anniversary, but it was not an anniversary date. I did not want him driving with the children, and things were not moving along with legal aid or anything that I was trying to get done on my end for court. And I offered to do a one-time co-parenting meeting, and he asked where, and I said at a Mexican restaurant in Long Beach, and we drove there separately. This was an hour-long occasion, and I asked for no photos to be taken of me, and next thing I know, in the mail, I have photos being delivered of me at the restaurant. We barely spoke 2 words. He's claiming that it was this lovely date, but it was literally, here's the kids. We're going to sit and monitor while we hang out. And then we let them walk up to the beach for 15 minutes, and they walk up to the rocks. And I have a photo. He took a photo of me walking up to the rocks, but we weren't communicative. It was just for him to say hi to the kids, eat a dinner, and we went separate ways. The next day, I had a falling out with one of my friends that we were staying at. And this whole time, Luciano was trying to get me to go back to the home and move back in. And I did not want to do that. I was fine having communication. He was still trying to power and control every narrative, every day of my life, even though I was away from him. I still felt controlled that I had to go see him. I contacted the police on him September 4th at my mother's residence because he stalked my phone and found me. He has a other claim, which is perfectly fine, but I don't know how else you would find me if you weren't stalking my location. He was not in contact with the kids from September 4th to September 13th. Him and I were having minimal communication, but I was just trying to figure out my new life without him. He was pressing me to go to court. He was pressing me to do all these things. And I was going on the timeline and trying to get a new job and move into a place and all of these things all at once, as well as leaving an abusive relationship. That is a lot. His control was very much just hurry up and come home to me. Just be with me. What can I do to make you be with me? He was helping when he met me on the 13th. He was very much about the kids for the first time. I left Luciano Torres because he was not a good hands-on father. He did not get out of bed. He did not help me. He did not. He worked all day long and had a beer in his hand when he was awake. He would leave for excessive amounts at the night, driving and speeding and getting pulled over. I had no help. And on top of that, I was a sex slave. So I'm being physically abused at night and whenever throughout the day that he wants. I had to be accessible to him all day. And on top of being a mom, I had no help. I couldn't do it anymore. I walked out. I was doing it alone. And when I met up with him, it was, oh, the kids, let me see the kids. I want to be with the kids. Let me help you get the kids in the car, and things he'd never done before for me, things he never helped out before. So I was like, oh my God, you're helping me. This is wonderful. But when we would go home, it was texts about, when are you coming back to me? And those are texts that he didn't want to submit. But you look so nice in those jeans, compliments I've been waiting to hear for 4 years, things I've been begging for 4 years. It was once I left and he knew I was going to court, it was just power and control constantly. I was constantly going through it. I couldn't get up and go to work because he's bullying me in the morning, first thing. But backtracking to the 14th, I'm so sorry. On the 14th, we were having a falling out with my friend's house, and he offered to get us a hotel room for the evening. And he paid for that online, and we went to the hotel, and he was not staying the evening. He helped keep the kids for a few moments so I could run up to the other house where our things were with my friend. And he left when I came back. We went earlier that day to go to the Halloween store to get the kids their Halloween costumes. He offered to purchase them. He was very much offering to help with everything that he normally wouldn't have. But again, he was, well, I want the addresses to all the apartments you're applying for. I want to know what you're doing at every given day. I want to know where you are. It was still so much abuse happening mentally on my end. And I just was like, why did I even leave you? I left for a reason, because I don't want to deal with your control. wasn't being sexually abused anymore, but I'm still noticing abuse every time we spoke. And his shift of I'm this best dad once court got involved is mind-blowing to me, because those are things I begged for him to do for 4 years, even with my son, that he claims that he has this wonderful relationship with. All Luciano Torres was he was doing was just offering financial help to the kids, but mom has everything else covered. He doesn't need to ask about their day because mom's got it covered. So coming from not having any ounce of support from him, and then now he's, oh, I'm this hands-on dad. Let's go to the children's museum. I'll take you to Walmart. He never went into a store with us. So now all of these big changes were happening, and it was nice. It was lovely, but I'm still going home and dealing with mental abuse, emotional abuse from him. Control, power control, that you must do it my way. I once court's involved, I don't need to talk to you. I don't need to I'm done with you. I don't have to deal with this. And I'm being told that I got this protection order to retaliate, but I was on the police getting told to get a protection order. And I'm like, I don't know what to do. I don't know what I'm doing. So as far as this, me and him having this dating thing, like, or him getting an apartment for us, none of those things are true. I've done all of this on my own. I only have one job. I did get a second job because my first job wasn't giving me enough hours, but I am now full-time with that job.
On that point, Ms. Wolski?
Yes.
On your job, tell me, do you know what your hourly wage is?
I make $19.51 an hour, and right now I'm up to like 36 hours a week.
And how long have you been at that job?
Since September 9th-ish.
Okay. And is there sometimes jobs will have kind of a probationary period, and then after you've completed that probationary period, then the pay increases a certain amount? Is that your situation?
I think so. I do have a training coming up in December, and I believe I may be bumped up to $20 an hour after the trainings are completed.
Okay. Thanks. Appreciate that. Go ahead.
So then once the courts got involved, I did go no contact, and I was advised to have the kids were with me. I do not want him driving, and I did not want him driving in the vehicle. And this 30-day road trip that we're talking about constantly, we were fighting really, really bad up to this point. And because I just couldn't do this sex slave job anymore. And I wanted to go get a real job. That was the big complaint all 4 years, is me constantly wanting to work, but I had to be available to him all day and to the kids because he wasn't available to them all day. So he offered to start giving me a monthly allowance, which I do have every single Venmo receipt from 2019 to 2023 that I will be submitting, as well as a evidence from this sex slave stuff. I just had to find out which way the best way to submit that is, because there's a lot of things on it that I didn't want seen by everybody. This 30-day road trip, he was taking Mason without me. He said, she's going, and I, knowing what I know about his daily to-day care of her, I would never have let her go that long without her mama, with that man.
Does he have any other children?
He does. He has a 20-year-old.
Okay.
A 20-year-old, and that child was with us on this trip.
Okay.
And Luciano drank the entire trip. I'm sorry, Your Honor.
Oh, I was just going to ask you one quick question about Corby Johns and your mother. Can you tell me just a little bit about that issue was raised?
Yeah, Corby Johns is my sister's fiance, my brother-in-law, and he was in our life pretty much over at our house every month. Even in August, we were together. So Luciano has claims about him being unsafe, but he was in our house every month for get-togethers, for occasions, for everything. And him and Luciano had a really good friendship. Honestly, they would drink and smoke together and hang out the whole time he was in our house. They would stay the night. And then my mom, was that the other person?
Yes.
Kelly Weishar, she's my mom. Yeah, she's my support right now. I'm not sure what else you want me to say about her right now.
Okay. And then there was concerns raised regarding marijuana use. Can you address that?
Yeah, Luciano did get me dependent on marijuana 4 years ago. I was not a smoker until I had met him, and my sex slave job was getting to be where I couldn't mentally do it. And he smoked behind my back. And once I found out that he did it, he was more open about doing it. And he also told me to smoke with him. And he would start off giving me joints and like flower marijuana. And then we slowly started doing it more like medicinally, I guess, together. He claims that he has a bad back, but he went to get a medical card in order to go get his kid from foster care 4 years ago. And we smoked together. I mean, it was an everyday together thing. And I was dependent on it due to him, due to this job that he's had me do.
Does that dependence continue to today?
Occasionally, yes, but I have cut it down. I am speaking to someone on the 25th to try to get some help with my anxiety, because that is the main reason right now. But it's not been where I'm purchasing anything or I've definitely not been partaking.
Can I circle back to your job? You said you're in $19.51 an hour and you're up to 36 hours a week. If at a 36-hour a week, do you know what your gross and net is?
I'm not sure right now. I'm not currently making the 36 hours because me and both children are in therapies, and I am in a few parenting classes as well that do take some of the time during the week. So technically 36 hours is what I do have in place, but it is realistically only about like 33, 34 hours a week due to all of our appointments.
Okay. All right. Thanks.
And I do have the ADP app. I am trying to get logged on to that with my job, so I can print out the pay stubs for you. I have I think a 3 or 4.
Okay. Thanks. All right. I think I have a pretty good idea of where you're coming from and what your position is. Do you have anything else you want to share before I turn the time to Mr. Foley?
So with his driving, that was the big reason why I stayed in contact with him over the month. I did want him to see his child. I did not ever I wanted him to make some changes, honestly. That's what I would ask, is that changes are made. Because he did get pulled over twice with us in the car, and that was just the 2 times he did get caught within this last year. I did submit plenty of times of him driving and speeding with us in the vehicle, but I do have the police reports from those evenings stating that we were in the car, and when he was asked why he was driving those speeds with children and vulnerable people in the car, he didn't answer. But continues to do it anyway. My concern is that when I was in the car, okay, there's at least another adult, but what happens when there's no other adult in the picture and he's still doing these things? So the driving is my biggest concern. And now that I have no contact with him, I do feel a little bit better about this going forward of him hopefully being able to make changes in order to have her more than what I did offer that's just what I'm willing to negotiate on right now, because of all the things that I do know that he does do on a normal basis. He has only had her one overnight in her entire existence, and that was July 31st of 2021. And other than that, she has been in 100% my care. Everything she has was gotten by me. And that is also another question I do have about all of our belongings that are still in his home. We left with just the clothes on our back, and we have gotten to go back a couple of times in September to retrieve a couple of things. But I mean, I'm talking about the kids' toys that I've put in the house. I have pictures and documents that I haven't been able to get. I didn't expect to not be able to just get everything out after moving, but with the way that it is, a protection order did have to happen with our communication.
Okay.
And then I'm sorry, Your Honor, I do have a vehicle in my name that is also in Luciano's name, and it's broken down right now. My dad is trying to work on it, and so I can sell it. It is a Range Rover, and I'm trying to figure out what I need to do about that to get his name taken off. We both put half for the vehicle. We both paid half for the vehicle. I put the down payment, he paid the rest. It was a $10,000 vehicle. I do have the title with me, but the vehicle is not drivable right now. And I am borrowing a vehicle from a family. So I'm just trying to figure out what I need to do for that as well.
All right. Thank you, Ms. Wolski. Mr. Foley?
Thank you, Your Honor. I refrain from objecting because there's obviously a lot of material that she mentioned that wasn't contained in any of the written materials that she submitted. But the reason for that, Your Honor, I think, is to make a point to you that obviously the protection order, for whatever reason, was a strategic filing. She was not afraid of him, as she indicated in her petition to the court. As you heard her testify, she continued to meet up with him, to go to his house. I mean, obviously there was no fear of my client. So that's unfortunate, but it's where we find ourselves today. Going back to the issue of judgment that I'd indicated, and I think particularly the way she framed her reference to the protection order, she wanted things to change in terms of a relationship with him. And she felt, okay, if he did these things, then in terms of their relationship, it would be okay for him to have more time with his daughter. Unfortunately, that's not the standard. The standard is what is in the best interest of the child, not what is in the best interest of mother and her relationship with father. And so, again, I think it shows the lack of judgment on Miss Wolski's part, because she's indicating to the court that, yeah, she's good with him having more time, and yet she's withheld the child without any explanation from my client since, at least October 18th, when she was served with the papers. The other piece that I think needs to be mentioned, and I mentioned it to Judge Warning, which is why I think he limited this order to 90 days. There's no evidence to support, and there's been reference to this, sex slave stuff. There's no evidence supporting that. There's no declaration from family members, from friends, from coworkers, or whoever. There's no CPS reports, no founded findings, not even an investigation. There's no police reports that you would normally see in a situation like this. And then she refers to his control over her in photos, and she ran this by Judge Warning, and there were no photos to support any of the allegations. The issue is my client holds a senior position with the state of Washington, and if he laid around all day drinking whiskey and drinking beer, he wouldn't be working two jobs, number one. Number two, he wouldn't be progressing up the ranks with the state of Washington or any other employer for that matter. So again, I think it's challenging for the court. It was challenging, I think, for Judge Warning, but to reconcile these types of allegations with the objective evidence that the court has before it. So again, we're asking for my client to be designated the primary custodial, for mother to have alternating weekend visitation, and a carve out, and I think this is kind of what Judge Warning was suggesting that your role or the commissioner's role would be in this case, is to carve out something that accepts the protection order for communication between the parents for purposes of arranging visitation, purposes of anything having to do with the children. Everything else, I understand the order will remain in place, but there does have to be a carve out for that type of context. So that's our request for this morning. This business about driving, that's just the last point I'll make. My client has a valid license, proof of insurance. Again, I don't, from looking at the materials, there's photos of her in the car. But again, I can't make heads or tails of what any of that means. So thank you, Your Honor.
Okay, thank you. Ms. Wolski, I'll give you just a few moments. So I'll just give you a few moments. So go ahead.
There is a CPS investigation going on. I have been investigated already, and I was told that his investigation is still ongoing due to the negligence of Mason Torres.
Now I am going to object, Your Honor, to hearsay.
Sustained. So Ms. Wolski, the objection is sustained. That means that it's not contained in any documents, and it's a statement from somebody who's out of court that we can't examine and talk to. So you won't be able to discuss that particular.
Yeah. Okay. And then I do have my my contract here that Luciano Torres and I had, that I will be submitting to the court. This is the one that I was trying to figure out if I could seal and which route to go. And this will be mailed to you, Mr. Foley, as well.
Same objection, Your Honor. She's testifying to a document that hasn't been submitted. I haven't seen it. I have no way to address it.
Yeah, the objections noted. I think she's just stating that she's going to be submitting that.
Yeah, there is more evidence to be submitted. I was just trying to figure out how to have that sealed, as there are explicit photos and comments and conversation on there that I just didn't want open to everybody to see. But I don't think I was able to have that sealed. I was called this morning whenever I filed that. They called me back this morning saying that I couldn't have it. So I am trying to still figure that out. Yeah, we do have open cases there. I do have the traffic police reports from his tickets, and then I am still trying to obtain the police report from the night I called the police when they came to my mom's address on September 4th. So I am in the works of getting all of that still, and we'll submit those.
All right, thank you. All right, so we're here this morning on Mr. Torres's motion for temporary orders. As far as child support, there's a request for child support. I think I have a fairly clear idea of at least one of Mr. Torres's jobs. The other one, I don't have a very clear idea of what amount he's earning. And I think I'm kind of in an equal position with regard to Ms. Wolski's earnings. We have a general idea, but I think the precise numbers are somewhat they're not present. So I'm going to reserve on the issue of child support until we have further information about Ms. Wolski. There's something called a family financial declaration, and then pay stubs. That information is very helpful in making a determination. And then Mr. Torres will submit additional information related to the SSI company. So that issue is reserved. So the main issue before the court today is the parenting plan. And both parties alluded to this. The court's focus is the best interest of the child, Mason, and that's what we look at. And there's a lot of different factors that go into this. And so, taking a look at the evidence that was presented to the court today, it sounds like Mr. Torres is a good wage earner, has a good job. I assume he works hard at his job. Ms. Wolski, during their time together, didn't really work outside of the home. I guess that was an agreement or an expressed preference between the parties. And that so what we know is that during that time frame, the way it looks to me is that Ms. Wolski tended to be the primary caregiver to the child, and Mr. Torres, while working at home, did have some interaction, but during the workday he was pretty focused on his work. And I think the evidence shows that Ms. Wolski tended to be the primary caregiver of the child. And so I'm going to designate her as the primary parent in the parenting plan. I know that there's concerns related to maybe a lack of overnights that the child has spent with Mr. Torres. Does have an older child, so he does have parenting experience. It's not the first rodeo, if you will. So I'm gonna designate his residential time to be on alternating weekends, first, third, and fifth weekends of the month, as designated by a Friday at 5 p.m. until Sunday at 5 p.m. And also every midweek visit from 5 to 8 p.m. Now, with that, the protection order that's in place, it becomes a little tricky as far as exchanges. So the parent whose time will begin with the child, so that could be at the beginning of a residential time or the end of residential time. So the parent whose time is starting, they'll need to arrange for someone to pick up the child, meaning with the protection order, Mr. Torres will have to have a third party be the person that does the exchange, because he can't be there in proximity with Ms. Wolski. And then when Ms. Wolski picks up the child to start her residential time, Mr. Torres will have to have a third party there presenting the child. So, and I'm not sure if the parties have discussed an exchange location or not.
Your Honor, I was going to bring that up. I'm assuming Miss Wolski is living north in Rochester with her mother. Is that correct? Or are you back in Longview, Kelso?
I have an apartment in Kelso that I reside in with the children.
Okay, great.
And then,
so,
go ahead.
Well, I was going to say, where would be a convenient pickup and drop off?
Hall of Justice. Is that Hall of Justice?
The Hall of Justice in Kelso.
Okay.
Oh.
Your Honor, I mean, I know how those things work. I mean, the building itself offers no protection. So maybe what we can do is the sheriff's office, which is across the street.
So when you say across the street, sheriff's office, across the street, because the Hall of Justice houses the sheriff's department.
Oh, okay. All right. Yeah, I just wasn't sure if she was referring to the courthouse specifically. So
yeah,
that's fine.
So
that'll be.
Yeah, okay. So we'll do that. We'll do the exchange location will be the Hall of Justice, which is located at 312 Southwest First Avenue in Kelso. It houses the courts, the prosecutor's office, and the sheriff's office also. That'll be the exchange location. As far as I'm going to restrict marijuana use during the residential time with the child unless it's prescribed by a physician at a particular increments, which I don't think I've ever seen a prescription for marijuana that says take it 3 times daily or once at night. I've never seen that. But if it is, then that would be allowed. But otherwise, the marijuana is prevented or prohibited from being ingested during the time with the child. I'm also going to, pardon me, impose a restriction on both parties. Basically, it's a requirement that they obey all traffic rules while driving with the children. I think that's important. That will address that concern, hopefully. With regard to the belongings that Ms. Wolski mentioned are still in the home, I think that's maybe something you could speak to Mr. Foley and work on particulars on that. You know, sometimes if the negotiations break down, then you can bring a motion to the court to address those particular belongings, but usually the parties can work that out.
And Your Honor, if I could just interject on that.
Yeah.
So Ms. Wolski, if you want to make a list of the items that you would like to have, go ahead and do that and send it to me, and then I can forward it on to Luciano. And then to the extent you guys agree, we can make arrangements. If there's disagreement, then as Judge said, we would take it back to the court.
With her being in his care, I do want to make sure that she has things already there. I have provided most things for my new home for her, but I do want to split up some of her toys and stuff and some of the stuff that's left behind. That way he'll have a bed for her and toys when he has her.
And Your Honor, I wasn't sure if you were finished. I don't want to interrupt the court. But I do have a question on starting visitation.
Yes. Let me finish up and then remind
Okay.
the issue. Excuse me. The issue with Corby Johns, I'm just going to enter a kind of a cautionary protection that Corby Johns not be left alone or unattended with the child. So there'll always need to be somebody, another adult in the presence of the child if Corby Johns is present. So
Yeah, and I already have taken that into play as well during this time.
Okay, great. And then as far as the beginning time for the visitation, so today's the 20th, and if you look at the calendar as defined by Friday, the weekends, so the first weekend is the 3rd, the third weekend is the 17th, the fourth, or the 1, 2, 3, 4, fifth weekend would be, well, the first and the fifth is the same, so December 1st. So we're looking at a December 1st start time.
And so my request, Your Honor, would be for November only, if we could have this weekend, because as I indicated, my client hasn't seen his child in, quite some time. So one thought would be for the month of November, we could have visitation beginning Friday, the 24th at 5 p.m., ending Sunday, the 26th at 5 p.m. Then mother would have the remainder of that week, and then father would have the 1st and the 2nd, and then we'd be back on the 1st, 3rd, and 5th. I realize it's 2 weekends. Technically, it's 2 weekends in a row, but I think given the circumstances, it's an appropriate request.
Okay. So I think, there's concerns related that the father hasn't seen the child for a period of time. It's alleged to be from October 18th. So I want to just kind of ease into this a little bit. So it'll be Saturday, the 25th at 5 p.m. until Sunday, the 26th at 5 p.m. for the first visit. And then we'll kick into the 1st, 3rd, and the 5th, which will begin in December.
Okay. Thank you, Your Honor.
So let me ask, that's the court's ruling. So let me just ask if the parties have any questions or clarifications. Mr. Foley, Ms. Wolski?
I don't have any more questions.
I don't think so, Your Honor. Can I just ask if my client could go on screen, and I just want to make sure it's clear with him. So Luciano, can you turn your camera on? Uh-oh.
See me?
No. Well, as long as I got you audio, do you have any questions about the court's ruling?
Not at this time, no.
Okay. All right, Your Honor. I think that takes care of it.
So let's talk just briefly about a date for a presentation. So this is a motion brought by Mr. Torres' attorney, Mr. Foley. So he would be expected to prepare the parenting plan. So we'll take a look at a Tuesday in which we could set that for a presentation. So what that is, Ms. Wolski, is that the court made some orders related to the parenting plan, and then Mr. Foley will document those or summarize those in a document, the parenting plan, and then he would submit that to you for your review, and it's submitted to the court for its review. And then if you have any objections, you could note those objections by filing objections and say, hey, the court didn't order this. This is actually what the court ordered, or you feel that the particular language is better with your version. You could submit that. And then we'd come back on a particular day for that presentation. If you agree with what Mr. Foley drafts and he says, oh yeah, that's accurate, that's what the judge ordered, then you could simply sign off on it and then return it to the court, and then I would sign it. However, if you have any objections or concerns about it, then we would look at a date for a presentation in which both parties can argue their points. So we're probably looking at a minimum of 2 weeks. So the earliest would probably be on December 5th. And I'll just ask the parties if the 5th works for each.
Yes, Your Honor, that works for me.
Yes.
Yes, Your Honor.
Okay, great. So we'll look at December 5th. We will set it for that date, December 5th at 9 a.m. for the presentation. Mr. Foley will get those orders out to you, Ms. Wolski, and then if you have any objections, file those objections with the court and send Mr. Foley a copy of the objections.
And then, Ms. Wolski, I will need an address, or, well, let me ask, I'll need an email address and a street address.
I have received something in the mail from you at my current address.
So we'll
Yeah.
just use that one then.
Yeah.
Okay. And then, Your Honor, I did have a question on the protection order, because this order from the court, Ms. Wolski, is effective today, even though we don't have written documentation of it. So I realize there's a protection order. I think we get around that by the third party. But how do you want me to handle is the court entertaining a carve out at all for communication regarding the children?
I am. I think that's important. If there's ever to be some type of an emergency related to the well-being of the child, the parties need to communicate regarding that.
I do agree with that, but I would like it to just be where it is only about Mason, not about Jackson or just Mason.
Yeah, I am creating a carve out. I think that's appropriate that their communication would be allowed in contravention to the protection order for solely related to the emergent or emergency needs of the child. So I think that covers it. I think there's a lot of things that, you know, could go through maybe a third party to share information, you know, like I'm running late, that could go to a third party. That's not an emergency. But if there's any type of emergency, then they would be allowed to communicate.
Great.
Thank you for that clarification, Mr. Foley.
Thank you, Your Honor. All right. Thank you very much.
All right. So if there's no further questions, we will see everybody on December 5th at 9 a.m. for the presentation. All right.
Great. Thank you, Your Honor.
19th. All right, Mr. Foley, I saw you signed on Torres v. Wolski, cause number 23-3-00442-08. I see Mr. Foley had joined. Do we have Melissa Wolski?
Yes, Your Honor, I'm right here.
Okay.
Your Honor, forgive my camera troubles. So I'm not, there we go. I'll just have to go off camera, but
That's fine.
okay.
So this is on for a presentation of order. That's my understanding of the only thing that it's on for. I would not be the appropriate person to, unless there's an agreement on it, for me to hear it since it was in front of Judge Evans.
I agree, Your Honor, and I know Ms. Wolski had some objections to the form that we presented. So,
okay. So I believe Judge Evans will be back next Tuesday. So I think that's most appropriate to just set it over to that date.
okay.
So that would be, let's see where we're at, to December 12th at 9 a.m.
All right. Thank you, Your Honor.
Thank you.
Thank you.
There's several concerns that you're worried about, and so you're raising those up at this time. So the purpose of today's hearing is to look at a summary of what happened on November 21st. So the court made some rulings on November 21st, specifically about parenting plan. And we're here to have that summarized and make sure that the proposed summary that Mr. Foley presented is accurate of what the court ordered on that particular time. So if there's new concerns that are coming up or boiling up, then you'd have to file some type of motion to address those specific motions. For example, you indicated that there's another woman that's living with Mr. Torres and concerns about criminal convictions and the like. That if that's a concern, then you'd have to file a motion and allow Mr. Foley notice so he could respond to it. So today's purpose of our hearing is to focus on this presentation of this order, whether the summary presented by Mr. Foley is accurate or not accurate according to what the court ruled on November 21st. Does that help?
Yes.
Okay. Well, as far as this proposed order, the parenting plan, what other areas do you feel that it's not accurately portrayed what the court ordered?
I'm concerned that Luciano Torres has to spend 5 days in jail for his traffic ticket he got on July 2nd. I found this information out, and it was not brought to my attention that he was going to be having Mason while he was spending his 5 days in jail, which means Carly Partain, the woman living with him, would be having my daughter when he does not have her. That is my concern, that he's not addressing to the courts, that he has jail time.
Okay. So any other concerns about the proposed parenting plan that was submitted?
No, I don't believe so.
Okay, I've signed off on that proposed parenting plan, so we'll get that.
Your Honor, if I could just raise one issue. Ms. Wolski did have, I think, a very good suggestion at the beginning of this. As the court's aware, there had to be a third party available for the exchanges, the pickups and the drop-offs. And she suggested Mr. Torres pick the child up at daycare Friday afternoon. It doesn't, I mean, that solves the pickup problem. The drop-off is still the issue. That's one of the reasons he had this woman actually come up from Texas so that she could do the third party drop-offs. That's not going to last forever, Your Honor. And it's not a significant other live-in relationship. It was just a matter of meeting the conditions to get around the protection order. So my suggestion is to take Ms. Wolski's recommendation and go a little bit further and just do the return to daycare on Monday, as opposed to return on Sunday night. Now, that should only be the case, I think, for about another 60 days, because Judge Warning, the protection order that he entered, he made it effective for 90 days. So to avoid the issue with having a third party do the transport, we've solved the Friday pickup, but my suggestion is just to return the child to daycare on Monday, and I think that will solve the problem.
So you're looking at paragraph number 12 of the proposed parenting plan?
That's correct.
So Ms. Wolski, looking at paragraph 12, here it indicates the child will be exchanged for parenting time, picked up and dropped off, daycare or school if not in session. So that's where the exchange would occur at daycare. And if not, then if it's not in session, then it would be at the Hall of Justice. So, Mr. Foley, what are you making a proposal to change that according?
Well, yes, just to do the drop off at daycare, and that would occur Monday morning. So,
so just as it says on the first line, the child will be exchanged for parenting time at daycare.
yes.
Okay. Ms. Wolski, on that paragraph number 12, basically it's Mr. Foley is proposing that it just read the child will be exchanged for parenting time at daycare. And if it's not at session, then at the Hall of Justice.
So are we stating that he's taking her to daycare on Monday? Is that what you're proposing?
I think that's the proposal by Mr. Foley.
Right.
I have a third party person doing the pickups or for me at 5 p.m. or 8 p.m. on Wednesdays and every other Sunday at 5 p.m.
Okay.
I don't think that I need to have him take her to school on Monday when I have this side figured out.
Okay.
And we had our hearing. It was Thanksgiving weekend. I didn't have a third party person at that time, and which now I do, and she is doing the drop-offs. Everything is going well with that.
Well, actually, there was an issue, Your Honor, and that's why I proposed it, but I'll defer to the court.
Yeah, so as far as what the court ruled on November 21st, the court ruled that the parenting time of Mr. Torres would be the Friday, the first, third, and fifth weekends, Friday from 5 p.m. until Sunday at 5 p.m. Mr. Foley's proposal extends that an additional overnight, which the court did not order. So I'm going to leave the transportation arrangements as indicated, that the child will be exchanged for parenting time at daycare or school, and if it's not in session, then it would be at the Hall of Justice. So that would take care of the Sunday, and that it also indicates that a third party will provide the transportation for Mr. Torres. So I'm going to leave that as is.
Thank you.
Okay, so I've signed off on that parenting plan.
So, Your Honor, just to clarify, then the exchange will occur Sunday nights at Hall of Justice?
Yes.
Or okay, not at daycare on Monday.
Right, because the parenting time ends Sunday at 5 p.m.
Right, got it. Okay, well, thank you.
Yeah, yep. So signed off on that. Then let's take a look at, there is a proposed temporary family law order. It's a 2-page order, Ms. Wolski. Basically, it's kind of a summary order, just says, hey, there's no money judgment. There was a motion for a family law order and a restraining order. There's no active military duty. It covers the care and safety of Mason. There's no fees ordered, and that there was a temporary protection order in another case that allowed contact in case of emergency involving the child. So any concerns or objections to that proposed order?
No, Your Honor.
Okay, that's pretty straightforward, so I'll sign off on that one. Next is a proposed protection order And it's a 12-page document. Ms. Wolski, did you receive a copy of that?
I did, Your Honor.
Okay, do you have any concerns or objections to that?
No, Your Honor.
Okay, Mr. Foley, I'll go ahead and sign off on that as proposed.
Okay, thank you.
Your Honor, was that protection order against me, or is that the one that is still for me against him?
Yeah, good question. This order restrains Luciano Torres and
Okay.
checks Melissa Wolski.
Okay.
So signed off on that. Then let's talk a little bit about child support. I reviewed the documents that both parties submitted. Ms. Wolski, do you want to go first and just share your view of what your income is and what you believe Mr. Torres's income is and how child support should play out?
My income is around like $1,400 a month, maybe less. One check I got was $800. One check I got was $500. I'm not really sure. I submitted the pay stubs.
Yeah, so it looks like you're earning $19.51 per hour, correct?
And I'm maybe getting less than 20 hours a week right now with all of the children's appointments, my appointments and therapies and parenting classes and all the sorts of things I'm doing extra right now.
So your net's about $1,400 per month, correct? On average. Okay.
Yeah.
Any input as to Mr. Torres's income?
His income is significant as he's working 2 full-time state jobs.
Mm-hmm.
I don't really know much about how much exactly he makes or what he has going on. So.
Right. All right. Thank you. Mr. Foley?
Thank you, Your Honor. We've pretty much spelled it out in my client's declaration. We're asking the court to basically just calculate child support based upon the state job that he has held for a number of years. The SSI job, as my client indicated in his materials, was taken solely to allow him to kind of catch up on debts and some back payments and things like that. As a matter of fact, Ms. Wolski had applied for benefits while they were still together. The state came back and said, no, you owe that money back. So he's also been paying that. So we're just asking that the court use the numbers that we had previously submitted for purposes of calculating and not include the second job, because again, I don't know that that's necessarily going to last. He's had that since January of 2023. And now that they're separated, I don't see that there's going to be a lot of additional debt that he's going to incur. So once he gets this paid off, then it's my understanding he plans to basically just work the one job.
Thank you. So in his declaration, he says, I'd like to secure the funds for that, meaning legal stuff matters.
Right.
I resign. So it sounds like his plan is to continue on there for at least a period of time, unspecified, correct?
Correct.
Okay. And then the figures that you provided, you've provided his gross at 96.54 per month and 74.46 net per month. Those are the figures you used, correct? In your worksheets, at least.
Right.
Okay. And then you're asking that Ms. Wolski be imputed at full-time or imputed at 19.51 per hour, 40 hours a week.
40 hours a week. That's correct. And that seems appropriate. If the second job is going to be considered, then it seems appropriate to impute at 40 hours a week.
And does his second job, is it subsumed or represented within the 96.54 gross and the 74.46 net?
Yes. That's my understanding.
Okay. All right. Ms. Wolski, any further input on?
Your Honor, I am aware that he has significant debt occurred from his criminal record. He monthly has to pay fines and fees that equal about $5,000. He has a Cadillac Escalade that he just got, and that is a significant $1,200 payment a month. He has a Cadillac or a Camaro SS he pays around $800 a month on. His insurance skyrocket. I mean, his debt is because of his choices, not because of anything that he's trying to pay off. It's because of his things that he's gotten since being with him.
Okay.
Well, Your Honor, my client spells it out in his declaration. I'll just leave it at that.
Thank you, Ms. Wolski. All right, so I'll set Mr. Torres's gross monthly income at 9,654 and his net at 7,446 for purposes of child support. As far as Ms. Wolski's net income and gross income, I'm going to calculate her net income to be at 1951 per hour at 35 hours per week. So I'm imputing extra hours that she's not currently working because it appears that she's underemployed at this time for various reasons. So that will set it at, I'm not exactly sure the exact figure. So that those figures of the 1951 per hour at 35 hours would need to be calculated and then placed into the calculator, and then combined with the 7446 net of Mr. Torres, it'll come up with a figure. So that means we'll be back for another presentation for child support worksheets and orders. And I'll ask the parties what would be a good date and time for you all to come back. Mr. Foley, since you're preparing that order, can you give me an estimate of what would be good for you?
We should be able to be back in, well, let's see. I was going to say 2 weeks, but
It's the 26th. Well, court will be open, but
well, what's the court's preference? I mean, I certainly.
January 2nd is looking pretty good, or December 26th is looking fine, either one.
Oh, why don't we just go with the second? That's fine.
Ms. Wolski, would that work for you?
Yeah, that's fine with me. I have requested a guardian ad litem, and I will be sending that document over to Mr. Foley. So we will have court on the 9th for that.
9th of January?
Yes, yeah. So I'm fine with doing that on the 2nd.
I'm wondering, and this is just a proposal, if we're going to be back here on the motion related to the guardian ad litem on the 9th, would it be okay to do the child support presentation on the 9th also?
Yeah, that would be wonderful, actually.
Mr. Foley?
Okay, so I will change that to the 9th.
Yeah, let's do that. So we'll set the presentation child support for the 9th. And
All right. Number 5 and 6, 233442-08 Torres versus Wolski. I saw Mr. Foley. Yes, I see Mr. Foley. Do we have Melissa Wolski on here?
Yes, Your Honor, I'm here.
Okay.
Morning, Your Honor.
Good morning. So in regard to the presentation of order regarding child support, is that matter agreed? Do we have signed off on that?
No, Your Honor. Actually, we're asking to have that put back on Judge Evans' docket. There's still some further discussion on the worksheets that were used, but we are in agreement with Ms. Wolski's motion for guardian ad litem.
Okay. So let me first address the presentation of the order of child support. If it doesn't sound like it's agreed, and so with that needs to be put on Fridays, Friday at 8:45. You want me to put it on this Friday at 8:45?
Actually, Your Honor, I'm going to be out of town until the 20th, so anytime after that.
That's fine.
Okay. So let's see, the 20th. So we could put it on for January 26th at 8:45.
That'd be fine.
Okay. Does that work for you, Ms. Wolski?
Yes, it does. Thank you.
Okay. So January 26th at 8:45 a.m. That is via Zoom. All right. In regard to the guardian ad litem, and sounds like there's an agreement to that, so that will be granted. Who are the next three?
Beth Fellows, Karen Lawrence, and Hunt.
So Ms. Wolski, do you object to any of those three?
As far as the guardian ad litem, I didn't know that that was still going forward. I was needing to still submit some documents for that. And since that happened, that was around December time, early January. And since then, I'm not so sure if I still am wanting to involve a guardian ad litem or I'm not sure if it's necessary, etc. So I'm not sure I just want to speak up about that just before we go into that. I didn't know if that was still going forward today.
It was noted on to go forward. So are you withdrawing that motion?
Yes, I would like to withdraw that because, like I said, they were needing more documents from me. And then I just had decided that it wasn't really that necessary, I don't believe, with our case.
Well, Your Honor, just to short circuit the process, we believe it is necessary. That's why we've agreed to it. So we would ask the court just to give us 3 names. I would be more than happy to prepare the order. If that doesn't work, then I guess I can put that on for the 26th.
Okay. So at this point, since it's her motion, I can't and she's withdrawn it, it's really not properly before the court. I understand
Sure.
what you're talking about, Mr. Foley. But at this point, just note it on to the 26th.
Will do.
Okay. All right, that's it for that matter for today.
Thank you, Your Honor.
That leaves Torres and Wolski matter 23-3-00442-08.
Amy Powers here for Miss Wolski.
Tom Foley, appearing for Mr. Torres, Your Honor.
Ann Height, guardian ad litem, Your Honor.
All right, counsel, go ahead on your motion.
Thank you. We have 2 different motions before the court today. We have a contempt motion and also a motion for other relief. Does the court want to hear those argued separately or together?
You can go ahead and argue them together.
Okay, thank you. I know that the court has reviewed all of the records, so I will be brief. I'm going to start with the contempt motion. We filed a motion for contempt because Mr. Torres has violated 2 different provisions in the parenting plan. Specifically, he's violated paragraph 8 of the parenting plan, which sets forth his visitation schedule. His time with the child starts at 5 p.m. on Wednesdays and 5 p.m. on Fridays. Despite this order, he has repeatedly picked the child up early from daycare, including as early as 10:20 in the morning. We provided proof of 11 different incidences when he did this and set those forth in our motion. He has also violated paragraph 12 of the parenting plan, which requires Mr. Torres to use a third party to provide transportation for the child. Mr. Torres argues that that provision was only in place because of a protection order that was in place at the time the parenting plan was entered. The protection order expired February 13th, and Mr. Torres has been at every exchange since that expired. Although it's true that there was a protection order in place that expired, the provision in the parenting plan says nothing about being subject to the protection order expiring. And Mr. Torres being present at the visit exchanges has been upsetting to my client and a stressful situation. So these are pretty straightforward. Mr. Torres doesn't deny his behavior. He's violated both of these provisions. They're straightforward provisions. We're asking the court to find him in contempt, and we're asking for $1,000 in attorney fees payable within 30 days based on this contempt motion. Moving on to the other motion that we filed, there's 6 pieces of relief that we're asking for in that motion. The first thing that we're asking is that the court correct a clerical error in the parenting plan, temporary parenting plan that was entered December 12th, 2023. According to the clerk's notes, weekend visitation was ordered to end Sundays at 5 p.m. and the parties have been exchanging the child Sunday at 5 p.m. Nonetheless, the order that was entered by the court shows that visitation goes until Monday at 9 a.m. We believe that's a clerical error, and we ask that the court correct that. Next, the parties have been separated since September, and my client has personal property that's still in Mr. Torres's possession. We're asking the court to set a date certain for that to be exchanged. We've tried through the attorney's office to negotiate this. In Mr. Torres's response, he did indicate he has it set aside, so I'm hopeful that this means we can arrange for pickup soon, but I'd still ask the court to set a date certain for that to be done. Or at least follow up on this at the presentation date if we have been unsuccessful exchanging the property by presentation. We asked to change a weekend in July, and Mr. Torres has agreed with that, so I won't say anything about that. Our fourth request was that Mr. Torres be prohibited from driving with the child. DCYF made a founded finding for negligent treatment based on reckless driving, which was made against Mr. Torres, and this child Mason was part of that finding. The finding specifically says that he put her at significant risk of being injured or killed based on his negligent driving. Mr. Torres indicates he does have a valid license. The GAL filed her preliminary report and also mentions concerns about his driving. So we would ask that the court prohibit him from driving with the child. Fifth, we ask that the court order that Mr. Torres destroy any videos and photos, explicit videos or photos that he would have of my client. He indicated in his response he's already done that. We would still ask that that language be in an order in case any new videos or photos surface or are found. Lastly, we're asking that the child be required to sleep in her own bed during visitation. She sleeps in her own bed at my client's house. There's no reason why she shouldn't be sleeping in her own bed at Mr. Torres's home. And that's our request for today.
Mr. Foley?
Thank you, Your Honor. I think the last one is agreed. The videos have been destroyed. As far as driving with the without the child, Your Honor, my client is under the microscope as a result of a driving charge that occurred prior to the case being filed. He is currently under the microscope, obviously, as part of his resolution of that case. He does have a valid license. He does have proof of insurance. And there's no reason to suspect that he is going to risk his contact with the child by doing something stupid in terms of his drive. So we would ask that that remain in place, not to mention the fact that it would be extremely difficult for my client to have to try to round up third parties to provide all of the transportation. My understanding is the change of weekends requested by mother has been agreed to by my client, provided that there's adequate makeup time, and I think that issue has been resolved. Counsel's correct. The personal property has been set aside. My client's only objection was Ms. Wolski coming through the house, so he has set those things aside. As far as this matter being paragraph 12, paragraph 8, I believe, is the visitation schedule. It is not, I would argue that it is not a clerical error. Judge Evans entered this order back on December 12th, and I recall it very specifically because Ms. Wolski wanted to make a number of changes, and Judge Evans basically said, look, the order has to reflect what my ruling was. And it says here specifically, the court addresses Ms. Wolski regarding the court has already made a ruling, and the orders presented today need to reflect that ruling. And then the court addresses Ms. Wolski regarding a new concern that would be need to be addressed with the new motion. Court signs the temporary parenting plan. And then the rest of it, he asks Ms. Wolski, do you have any questions or objections? And in each of those instances, the temporary parenting plan, temporary family law order, and the protection order, Ms. Wolski is noted in the clerk's records as having no objections. And I would argue that there's a distinction between what we call the November schedule, which was just alternating weekends, that changed in December of 2023. You'll note in paragraph 8, as of December 2023, Mr. Torres has the first, third, and fifth weekends for his visitation. And there's nothing in the materials would say that, since the child is in daycare, not school, but in daycare, there's nothing in there that says he's prohibited from picking the child up any earlier. And so I think that's consistent with Judge Evans expanding his time. As of December 2023, he wanted Mr. Torres to have more time with the child. Now, he's not showing up at mother's house in order to exercise this visitation. It's not impacting mother in any way. And so I would ask the court not to find contempt on that. I believe it's just a father wanting to spend time when he has the time with his child. And again, there's nothing specific in the order prohibiting that. As far as the pickup issues at the school, I did have a chance to look at mother's schedule that she provided from the school, but there's no documentation from the school saying that father is deliberately ignoring an order that he is supposed to sign the child out, and he's not doing that. It's clear that every time in the allegations that mother raises, every time my client picked the child up, the child has been signed out, whether it's somebody from the school doing it when he's picking up, or somebody, a designated third party, when he has somebody do that for him. So without more from the school saying that this is clearly a violation, I don't believe that that's necessarily a violation of any kind of an order. So the issue with regard to Mr. being present, if you look at the parenting plan, Judge Evans basically said, and I believe this has more to do, not so much with the protection order, but with the allegations of driving. There was a reckless driving charge pending at the time, and Ms. Wolski made mention of that to Judge Evans. And I think it was on that basis that Judge Evans said, okay, we'll have a third party provide transportation. But there's nothing in the order, the parenting plan signed in December. There's nothing in the protection order that indicates that my client can't be present for that. As a matter of fact, if you look at the protection order, there is no distance restriction. Judge Evans was aware that my client would be present at the exchanges, primarily because the child didn't know the third party that was going to be picking her up. And so I believe Judge Evans felt that, okay, I'm not going to allow him to drive until this reckless driving thing is resolved. But it is appropriate for him to be there to sort of ease the transition of the child. And so I would suggest to the court that when you look at it, it just says a third party will provide transportation. There's nothing further that says Mr. Torres is prohibited from being present. He has not had any contact at those exchanges. I will point out to the court, though, the parties have had extensive texting contact regarding the child's illnesses, schools, pickup, things like that. So they do seem to be, working through that. But it's been a significant amount of time since the December order, and my client has not violated any provisions as far as having any contact. And I think Judge Evans felt that was important. That's why he put a pretty quick expiration date on the protection order. As far as any comments regarding the guardian ad litem report, none of the guardian ad litem report, in my opinion, is properly before the court today. There was no motion to adopt any particular section or recommendation. So I will not address any issues relating to the GAL as I believe those items aren't properly before the court. Thank you, Your Honor.
Ms. Powers?
Thank you, Your Honor. Just briefly in reply, in regards to the clerical error in the order, if you look at the clerk's notes from November 21st, 2023, which were filed attached to my client's declaration, on page 2, the court clearly says alternating weekends 1st, 3rd, and 5th from Friday 5 p.m. to Sunday 5 p.m. Midweek visits 5 to 8 p.m. That is where I got the information. I was not involved at the time these orders were entered, but the clerk's notes set that out clearly, that visits are supposed to end Sunday at 5 p.m. And that's what the parties have consistently done since this order was made. So I asked the court to correct that clerical error. And then in regards to the contempt, the visit is, or the parenting plan is clear on its face. Mr. Torres's visits begin at 5 p.m. The order does not say they begin as soon as Mr. Torres gets off work and is available. They say that the visits start at 5 p.m. He is in violation of that order because he's been picking her up significantly before 5 p.m. And again, the order says Mr. Torres must use a third party to do exchanges, and he has not been doing that. So I do ask the court to find him in contempt and grant the relief we have requested.
Ms. Height, anything you wanted to say at this point?
I filed my report on the 15th of April, and if your honor has had a chance to look at it, there are some pretty serious concerns addressed, and the recommendations that I put forward reflect the concerns that have been stated here and go further than my recommendations go further than what is being discussed here. I don't know if your honor wants me to address any of that. I also had a conversation on May 2nd with Naomi Frine, the CPS worker who has been involved in this case. She expressed similar concerns to some of what I have detailed in my report. I will be writing some of this up in a future report, but for the court's consideration today, she feels like a third party is necessary for this child's safety. She also felt strongly that overnights at this time, until more information is available through professional evaluations, that overnights are not a good idea at this time. So that's some small amount of further information. I recognize you're not looking at my report today, but my concerns are I am extremely concerned for the safety of this child.
All right, thank you. So first off, in regard to the motion for contempt, a parenting plan is very clear as to times that are to be followed and are required for a parent as to their visitation time. So the court finds a willful and intentional violation of the court orders of this court, and the court does expect compliance with its orders. Mr. Torres has failed to do so by picking up the child prior to the stated time he is to have the child. If it says 5 o'clock, and that's what it is, and to make it his own time is not appropriate. I'm glad he's had good times with the child, but if it says 5 o'clock, that's where it needs to be. As to him coming to the exchanges of the child, as well as driving to at least some of the times, I find the language a little vague as to that part of it. So the court cannot find him in contempt as to that particular section of being paragraph 12, page 3. States the child will be exchanged for parenting time, picked up and dropped off, daycare or school. If not in session, then at Hall of Justice. A third party will provide transportation for Luciano Torres. It does not specifically prohibit him. And if somebody's prohibited, the court finds that it needs to be clearer as far as that part of it. So the court cannot find contempt there. Mr. Torres can purge the contempt by complying with the order, properly signing in and out the child as required by the daycare, which again is not a part of the contempt specifically, but to say that that's part of the responsibility of a parent when picking up a child. It's for the daycare to know who picked up the child. It's for the daycare to know when the child was picked up and to help keep track of the children in their care. So that is to be followed. As far as attorney's fees, the court does order $1,000 in attorney's fees for the necessity of the respondent having to bring this motion. In regard to the other request, number one, the clerical error can be corrected to that of Friday at 5 p.m. until Sunday at 5 p.m. It's very clear in the clerk's minutes on November 21, 23, that it is supposed to be Sunday at 5 p.m. So that correction can be made. Any further modifications or changes to that parenting plan, the court finds that it's necessary to bring a motion to specify what additional modifications need to be made. With the guidelines report out, it sounds like it might be appropriate to do so, but I'll leave it up to council to figure that out. As to the date certain to receive personal property, it sounds like things have been put together by the father for the mother to pick up. I'll just leave it to council to figure out a date that works for your clients to exchange those items or pick up those items. It appears that it's agreed upon about the weekend in July, and the idea of a makeup weekend on the second, sounds like maybe the second weekend of the month might be a good idea.
Do we get to agree to that? I wasn't in agreement with that. I thought we were going to discuss.
Sir,
it.
stop. So in regard to Mr. Torres driving the child, again, that one's difficult. I would ask that a motion be made if that's the request, because the language simply isn't clear about that. As long as he's properly licensed and insured, the court's not going to find an issue as to that part of it. The child shall be in a proper seat for a child of that age. As far as Mr. Torres immediately destroying any intimate images, a video of the respondent, and also shall not distribute, publish, or share any of those images or videos that can be included. Sounds like he's already done that. That's great, but that will be included in the order. As to the minor child is not sleep in the same bed, again, it sounds like that's in agreement. That's only appropriate. And so the child shall have her own bed during visitation with Mr. Torres. And the other one had to do with the hot tub. It sounds like it's already been secured. So you can go ahead and include it, but it sounds like Mr. Torres has already taken care of that as well.
That's correct.
All right. Anything else, counsel?
Thank you, Your Honor.
Can we set this for presentation in 2 weeks?
We can set it on the 21st.
All
Does
right.
that work for you, Mr. Foley?
Yes, Your Honor. Thank you.
Okay. All right. Torres, Luciano Torres and Melissa Wolski, cause number 23-3-00442-08. Anyone
Amy?
present on that matter?
Amy Powers here for Ms. Wolski. Mr. Foley and I have both signed off on the orders. I believe they're all agreed.
Okay. And those are the ones I'm to have, or are you sending them over?
We sent them over last week with both parties' signatures.
Okay. All right, I have those here, signing off on those orders. All right, those orders are signed.
Thank you.
Thank you.
Next, if we could please call Luciano Torres and Melissa Wolski, 23-3-4420 is the cause number. There we have Ms. Powers representing Ms. Wolski, I believe. Ms. Powers,
Yes.
I see her. There she is. And Mr. Foley is representing Mr. Torres. Mr. Foley, can you hear me okay?
Yes, good morning, Your Honor.
Good morning. Ms. Height is here as the guardian ad litem. Ms.
Good morning, Your
Looney,
Honor.
good morning. Ms. Looney is present, and I'm not sure if you're directly involved with this, but I think she's signed on, so you're welcome to chime in if need be. So we are here on a review of the case in large measure. There's an interim guardian ad litem report that was filed by Ms. Height in mid-April, which is on for today for a review. So I've reviewed that and the pleadings in the case. So I'll hear maybe first from Ms. Height. We'll hear from you, and then we'll hear from the parties respectively. And just in the petitioner respondent order. So Ms. Height first, and then Mr. Torres and Ms. Wolski.
Thank you, Your Honor. As you can see, this report was filed some time ago, and I have an expectation of filing a final report at some future date. I do have a couple of newer pieces of information, nothing that is startling or very different from what appears in my report, but I think it would be helpful for Your Honor to hear that I had a pretty lengthy conversation with the CPS worker in this case, Ms. Naomi Frine, and we discussed the history of it. And some details will be forthcoming in a further report, but the gist of it is that her concerns regarding this case were similar to mine. Her statement was that Mr. Torres is deficient, in her opinion, in decision-making regarding safety of the children, and she was terming that maltreatment rather than abuse, because during an incident in which there was some dangerous driving, no injuries occurred to the children at that time. She believes that Mr. Torres should have a third party present during all visitation, but she does not necessarily believe that professional supervision is needed. She agrees that mental health evaluations or some kind of counseling is appropriate for both parties. One concern that she had that I believe is being addressed through counseling at this time with Ms. Wolski is her statement was that she was concerned that it took such a long time for Ms. Wolski to understand that when she is in danger and duress, so are her kids, and that removing them should have been more of a priority earlier on. That was concerning. And then her final concern was regarding the co-sleeping. She feels like there should be no overnights, which is in agreement with my findings as well. She feels there should be no overnights at this time because of concerns of co-sleeping. She feels like there's no assurance that co-sleeping is not occurring. So those really just kind of underscore things that you will find in my report. In addition, I've had multiple conversations, email exchanges with both parties, phone calls since the filing of my report. And there have been some ongoing concerns from Mr. Torres concerning safety of Mason outside of his home. He has indicated that there's been some bruising. He sent several pictures to me. As you might know, picture quality is typically not real great between a camera and a screen. There were several pictures where I couldn't actually see any bruising. The one or two that I did see appear to be, and I don't mean to minimize bruising of a child, but there was a couple of penny-sized bruises on her knee that looked very typical of a toddler's bumps and bruises that occur. And again, I don't want to minimize that, but it was not alarming in any way. And I didn't see anything that indicated, nor did the CPS worker. Also of interest is that Ms. Wolski indicated to me fairly recently that the medication that she has been on for anxiety has recently been changed, and it has helped her, especially with situational anxiety that is more controlled, and she's able to function in a more stable way. So all that being said, Your Honor, I stand on my report. I know it's dated a little bit now. I would also like to have the opportunity of having a UA for Mr. Wolski at some time down the road. I know that he had a hair test. He did it at his own time and choosing, which I appreciate that he had it done. But there has been indication of heavy daily alcohol use. And I think by choosing the date that he went, it does impact the validity of that particular part of the score. So I don't know if that will come up in my future investigation, but I would like to be able to have a 2-hour window to have him get a UA if necessary. I don't want to do a whole another hair test that's pretty expensive, but I think that would be appropriate. So not having a final date for my report, I don't know how long this is going to go out. But at this point, with that being said, I stand on the report that I filed.
Thank you, Ms. Height. All right, can I hear please from Mr. Foley?
Thank you, Your Honor. I guess maybe I'll address this, the CPS comments. I'm not aware of those. We have not been contacted by CPS. The only point I would want to raise with regard to that, the guardian ad litem's report was done the middle of April, and Ms. Wolski brought a contempt motion for, I believe it was May 21st, or that's when the subsequent order was signed, and Judge Hahn did not feel that there was a basis to restrict Mr. Torres from transporting the child. As a matter of fact, it's stated clearly in the order that he is not restricted as long as he has valid license and proof of insurance, which he does. So,
Mr. Foley, was that hearing that Judge Hahn heard, was the driving issue, was that squarely in focus? Was that an issue that was raised during that hearing?
yes, Your Honor. My understanding was Ms. Wolski was asking that he not be allowed to transport the child because of his driving history.
Thank you.
And I may be wrong on that. I don't, Ms. Powers, I don't want to misspeak, but I believe that was before the court.
Thank you.
Okay. And then as far as the guardian ad litem report, you know, I guess to use a phrase that the court used earlier this morning, there is a lack of information with regard to this report. When I read through the report, and I've been through it a number of times, I counted through, I think, the first 10 pages, and there was no mention in the report how the child has been maltreated, how the child is in any kind of a danger. The focus of that report and those first 10 pages centered on this, and I guess for lack of a better word, bizarre sex life that these two folks had. And I think Ms. Wolski has done a masterful job of tainting people's opinion of Mr. Torres by emphasizing this. It should be noted that in the prior protection orders that Ms. Wolski attempted to get, she was granted protection order for her using those same arguments that are before the court today, the same arguments that were before the court last time we were in front of Judge Hahn. And in none of those prior orders was there ever any protection order entered for the child. And the reason for that is, at least in my opinion, is there is no nexus that's been established by the guardian ad litem, by opposing counsel, between the parties' sex life and Mr. Torres' ability to care for the child. And if you do go through the guardian ad litem report, you will not see a connection between those two things. And basically what they're saying is, we want to take away visitation between this child and her father because they have this, you know, bizarre sex life. And that's really not a basis. It certainly wasn't a basis for a protection order. So I would ask the court to keep that in mind. The second point is, it was interesting. The report was issued in April, and there was communication between Mr. Torres and Ms. Wolski about possibly adopting some of the provisions of the report. And Ms. Wolski basically said, you know, we're going to stick with the current parenting plan. as far as any exigent circumstances, there were none present that warranted, a fast return trip to the court. So I think that's of interest, because Miss Wolski and Mr. Torres obviously lived together for a considerable period of time. And I think, her lack of response to this is really due to the fact that she knows there is no harm to this child, even though they did have this strange arrangement regarding their sex life. The report also fails to look into Miss Wolski's, I guess, her pattern of removing fathers from their children's lives. She has 2 prior fathers of children that have no contact with those children. As a matter of fact, one of those children, for whatever reason, we haven't been able to determine why, does not even live with Miss Wolski. And I don't know if it's related to her PTSD, whatever her condition is. But the fact of the matter is that child lives, I think, with her mother. And I would point out to the court that Miss Wolski's PTSD, despite the mention made in the GAL report, pre-existed Mr. Torres. Mr. Torres is not the one who is responsible for her PTSD. So our position is, and I think the guardian ad litem mentions it, that there should be no overnights until the reports are complete. Well, my position is there should be no change in the parenting plan until all of the reports are complete. My client has a roommate, Carly Partain, who was interviewed by the guardian ad litem. She has a 3-year-old daughter from another marriage. They're roommates. They're not involved romantically. And I think one of the things that my client talked to Miss Wolski about was that, because there was a bathing, I think, restriction in the GAL recommendation. And he said, that's fine. Miss Partain will overtake or will assume those responsibilities. So that's one piece that was picked up. But it's interesting to note, Miss Partain certainly had the opportunity to relay to the guardian ad litem, I've got real concerns about Mr. Torres. I'm here, I live with him, I see him every day, I see him interact with his daughter, I see him interact with my daughter. And there was no negative comments made by Miss Partain regarding Mr. Torres' ability to care for his child. Mr. Torres also agreed to the no co-sleeping. And I know that was one of the concerns that was mentioned by the guardian ad litem and eventually by this CPS worker. So that issue has been dealt with. So our position is, until there's more information establishing what the actual nexus is between this behavior that the parents engaged in and how that negatively impacts the child, there should be no change in the plan. I've instructed my client to, I believe he's gone through the SUD test. I think it's appropriate. Whatever's being recommended, apply both ways. But unfortunately, this report, and I'm not faulting Ms. Height, because I viewed these relationship escapades, as I would call them, as certainly not within my realm of understanding, but there are people out there that do those kinds of things. And, if it's between the two of them, that's fine. But I think it had a real impact and really portrayed Mr. Torres in a bad light. And again, without that connection between that stuff and his care for the child, I just think it's premature to consider such a major change to the current parenting plan. Thank you.
Thank you. Mr. Foley, do you have any input just regarding, there was some indication that there had been, I think, 25, 27 driving infractions issued to Mr. Torres. Do you have any comments related to that?
Well, I'll tell you, he is not going to be on the Allstate Good Driver commercial anytime soon. So yes, there is a history of that. But again, those issues were all raised in front of Judge Hahn, and Judge Hahn stated specifically in the May 21st order that as long as he's got a valid license and proof of insurance, he's free to transport the child. And I'll be serious, Your Honor, he understands he's under the microscope. and he understands that if he engages in that type of activity with the child, then, you know, life is going to get a lot more difficult. So he seems like an intelligent person, holds a good job. I don't think he's going to do anything to risk the ability to transport the child, because he's sort of on an island here. Fortunately, Miss Partain came up from Texas. She's an old family friend. She's been there to assist in this, but if she's gone, he wouldn't have anybody as a third party able to transport the child according to the terms of the GAL, meaning that the child should know that person, be acquainted with that person. So I think he understands that life would be significantly more difficult if he fails to mind his P's and Q's on the road.
Thank you, Mr. Foley. Ms. Powers?
Thank you, Your Honor. First, I wanted to start out by letting the court know the court did on May 21st look at the driving issue. We had asked the court at that point to prohibit Mr. Torres from driving with the child, and the court denied that request on May 21st. The court did not have the interim GAL report in front of them that day. I had not added a docket notice to ask the court to review that at the same time as the other hearing and contempt. So the court was not considering the GAL report at that point. There's been a lot said about the sexual relationship between the parties, and I think what is being overlooked from Mr. Torres's perspective is that this was not a consensual situation, and based on the information in the GAL report and the information according to what my client has provided, this was a sexual relationship that impacted both day and night. There is no way that this relationship could not have had an impact on the children, because Miss Wolski had to take photos of herself on demand. We have here a situation where there's been this power and control dynamic throughout the relationship, and that's continued to play out after the parties have separated. The GAL report brings forth really significant concerns about Mr. Torres's lack of self-awareness, lack of self-control, and the way that he flies off the handle and reacts not only in his sexual behavior, but also in his driving behavior. And this child is a young toddler and does not have the ability to protect herself or stand up for herself when Mr. Torres is flying off the handle or reacting inappropriately. We think that the concerns are valid. We agree with the recommendations in the GAL report, specifically no overnight visits. And I would like to speak for a moment about the text messages. The parties did have some text messages ahead of this hearing where Mr. Torres initially agreed to follow the GAL recommendation to stop overnight visits. And my client was on board with that until Mr. Torres followed up requesting more visits than what were just recommended by the GAL. My client is in a position where she has been a victim to Mr. Torres on a regular basis, and they do not have equal power to negotiate. And so Ms. Wolski became concerned that this was another attempt for him to manipulate the situation and make her look like the bad guy. As a result, she did speak with the GAL, and she decided at this point it was wisest to just follow the court orders instead of trying to work with Mr. Torres. This does not mean she wasn't concerned about overnight visits. She was, but she felt it was more important to keep the power in the court's hands, since this wasn't just going to be a straightforward agree and do what the GAL recommended. So at this point, we do ask the court to go ahead and adopt the GAL recommendations. I understand if the court feels that the driving issue has already been decided, but regardless, we do ask that the court adopt the GAL recommendations.
Thank you.
Your Honor, I don't know if you want to hear from the GAL before me, or.
You opened your mouth, I'll hear from you.
Okay, thanks. Your Honor, and I'll just for point of clarification, when counsel indicates that my client was asking for more time than what was available under the GAL report, what he was saying was, right now, under the order, I have the weekend visits. And so what he would like to do, what he proposed to do, was do a Saturday visit and a Sunday day visit, Saturday day and a Sunday day. And what the guardian ad litem is proposing is limiting that to 1 day visit, the first, third, and fifth weekends of every month. So I don't view that as a substantial breach of the balance of power and bullying. Again, when I listen to counsel's argument, I don't disagree with her characterization of the parties' arrangement. I would argue, though, that certainly, despite Ms. Wolski's protestations, this was a consensual relationship. These same arguments were all made before Judge Warning, and Judge Warning was the one that issued the protection order in favor of Ms. Wolski. He did not include the child, and that was specifically because there was no nexus between all of the horrible, horrible things that Ms. Wolski says about Mr. Torres. There's no connection between that and how it impacts his ability to care for the child. I do have some concern about Ms. Wolski's ability to follow the order. There was a visitation scheduled this weekend. It didn't happen. Ms. Height was involved, I think, in the exchange of emails, and I think that's due in large part to Ms. Wolski's assumption that the court's going to grant this order. And that's a real concern. So I think until there's more information before the court regarding how Mr. Torres's proclivities affect his ability to care for the child, I still think it's premature. Thank you.
Thank you.
Your Honor, can I just very briefly reply to the last weekend?
Sure.
My understanding is that the visit did occur. It was an hour late. My client had gotten confused about which weekend it was. And when she realized her mistake, did provide the child. The exchange happened, but it happened a little bit late.
Thank you. Ms. Height, you unmuted.
Thank you, Your Honor. Yes, that when the first falls on a Saturday, which it does every once in a while, and the parties think that's the first weekend, I actually had 3 different cases call me disturbed about whether it was the first weekend or the 5th weekend. And so that it was confusing for all parties, and it was unfortunate that there was a misunderstanding, but the visit did occur. My concern, speaking of the nexus, is that there is a long history of compulsion and impulsivity that affect everybody in the household. So that would be my reply to that. Other than that, I have no other comment, Your Honor. Thank you.
All right. Thanks, everyone, for your input. I appreciate that. So we have a situation where we have a young child, and we have 2 parents who, during their time together, engaged in a sex life that is probably aberrational. If you look at percentage of Americans that engage in that type of behavior, it's probably a small percentage. So it's not unheard of, and it occurs. And so that's kind of front and center here. And then I think that the comments about the nexus are appropriate to talk about that, because you think about a relationship dynamic where a couple is together, they're trying to make it work. Oftentimes, just yesterday, I was in a criminal matter where an 87-year-old man was accused of hitting his 80-something-year-old wife in the back of the head at Rite Aid because she didn't get the right candy or something along those lines. And she was exceptionally defensive of her husband and thought this whole thing, and she used full language. She thought this proceeding was BS. And she said it didn't happen, nothing happened, and yet there was video of the episode. And so we know that it did happen. So I highlight that to emphasize that in relationships, there's dynamics, there's patterns that evolve that are not necessarily healthy nor necessarily beneficial for the full development and well-being of each partner. So what is, and I looked at this because I think, like I said before, the percentage of Americans that engage in that type of sexual relations is probably not, it's definitely not the majority. Would be my estimate. And so I tried to keep an open mind to all of that. And while doing that, I think that for me, that power dynamic and if nothing more than the mind control of where there's pictures on demand of private intimate parts of another human being, and the concern that if that didn't happen, that there would be repercussions, frequency of demands of physical presence and of another. And so that it raises this issue of self-control. It raises this issue of postponing gratification. It raises this issue, and it ties in, I think, to potentially to driving, where if you don't get your way, because a lot of times when we're driving, people do frustrating things. They cut us off, and they don't signal. They endanger us. So we feel frustrated by their actions. And so when somebody's in a relationship that's not following what you want them to do, that those issues of control and exasperation might come into play. And the same, I think, applies to the driving concerns, is that an individual who has, there's these rules, the rules of the road that protect everybody, including the drivers and other drivers. And then when there's a general unwillingness to follow that, there's a sense that you're above and beyond the rules of the road that are there for the safety of all. So I think that nexus has been met, in that the issue of the child. So here we have one parent that's exercising control, bodily and mind and emotional, over a fellow human being, their partner or spouse. Then you have a child who's really at a more significant disadvantage of ability to protect themselves. And then you can tie that into the driving. There's kind of a power dynamic there also, that one party feels that they're above those particular rules, those particular laws that are destined or aimed at protecting all parties, everybody on the road. So I think there's some concerns, at least at this point, that have yet to be explored and tamped down, if you will, about the safety of the child in respect or in connection with the father's ability to control himself, and also to not exert unnecessary or overbearing control over another human being. So the request from the GAL for kind of a surprise or within 2-hour UA regarding alcohol for the father, I'll grant that. I think that's appropriate, and that if there's an issue, it can be addressed. If it's not an issue, then that issue may be dispelled by that. The driving, I recognize that another judicial officer had possibly heard that particular issue, but I think here we heard more information about the 26, 27 infractions over a period of time that caused me to rule that the father will not transport the child in a vehicle. And I think that's important because it shows a really strong, very strong pattern of disregard for laws that promote safety. And if there's a past pattern of inability to abide by common sense rules that promote safety, even though it may be inconvenient for the driver, when that's been disregarded so many times, I don't have a lot of faith and trust that there would be continuation or a change of behavior. So there'll be no transport of the child by the father. So as far as the parenting plan, I think it's warranted that there be a change here also. And again, much of this may be dispelled through further investigation and evaluation, but at this point in time, there's some concern about co-sleeping. I think that's well-founded. And so there's not going to be any overnights for the father. So the mother will continue to be the primary custodial parent. And the father will have visitation on the 1st, 3rd, and 5th Saturdays from 10 a.m. to 6 p.m. and a Wednesday midweek from 5 to 8. And that Ms. Wolski will continue in her efforts with counseling. I tend to agree with Mr. Foley said that the PTSD is probably pre-existing, but I don't think that it was unexacerbated. In other words, it was probably exacerbated by Mr. Torres's conduct. So she'll continue in that. Mr. Torres will need to get a domestic violence evaluation and follow up with any treatment. Certainly collateral input from Ms. Wolski is appropriate. The SUD evaluation, substance use disorder evaluation for Mr. Wolski is warranted. And other than hearing from Mr. Foley indicate that it should go both ways, I don't remember in the pleadings if that was a specific issue that was addressed as far as Ms. Wolski's alcohol consumption. So since I don't recall that, it'll be in one direction, unidirectional, meaning the father will undertake that evaluation and any recommended treatment with collateral input from Ms. Wolski. The prohibition of no alcohol and no marijuana use 8 hours before residential time applies to Mr. Torres. The psychosexual evaluation and any recommended treatment is authorized and ordered with collateral input from Ms. Wolski. The exchange will occur at the Hall of Justice. The bathing issue, I think everybody's it sounds like everybody's okay with that, and that the father would not be bathing the child, that the roommate would be handling that and helping with that. And I think also this is important to note also that there's some indication of putting the child squarely in between the parents with coaching, quizzing, and questioning of the child. Please do not do that. Please do not force that position upon the child, and which will be highly detrimental to the child if that's continued. And also, the parties are ordered not to disparage the other parent. And if you want to put that in an affirmative tone, speak positively of the other parent, because that does nothing but build the child up and restore their confidence. So I think those are the items that I wanted to address. I may have missed some that were important to each of you. If I did, please let me know.
Your Honor, I think the only issue was, I know Ms. Height had some deadlines in her report. What kind of deadlines is the court considering?
And you're referencing a final date or the final GAL report, correct?
No, actually, I'm number 5. There was some talk about it completing a 5-panel test by May 8th, and I realized that applies to, the SUD, all of that. Does the court have a preference as to when those things should be accomplished?
So I think that one was accomplished, was it not? He
Right.
took the 5-panel and it showed THC metabolite. As far as you're talking about the additional UA, kind of the surprise UA provision.
And then I'm assuming the court would just order a reasonable period of time as far as scheduling, like with Dr. Johnson, those kinds of things, because that is going to create some difficulty.
Yeah, any efforts to get those appointments scheduled soon and get that started promptly is definitely the court's expectation. As far as the UA, the reasonable time period, I think a 2-hour time period to make arrangements. If you're in the middle of a project or doing something at home or work, you get the notice, 2 hours, kind of wrap things up, make some adjustments. And I think 2 hours is a reasonable period.
And then just as far as sort of my client's road back to overnights and transportation, I understand the evaluation from Vancouver guidance that's going to impact overnights. Can the court give my client some idea of what it would be looking for as far as getting back to the point where he could transport the child? I mean, he's dealt with all of his prior issues. There's no outstanding fines, no suspensions, things like that. So I know he's going to ask me, what do I have to do to get back to that point?
It's a good question. I don't know. The concern that the court expresses is a pattern of disregarding laws of safety, rules of safety. So whatever he feels that he can do to build or restore that confidence in his ability to and willingness to follow those rules would be manifested in some way that I'm not exactly sure.
maybe a NHTSA class or some type of a driver safety. Would the court consider those?
So at times when persons have engaged in behavior that's maybe aberrant or not following the rules. So education generally is well looked upon. If there's education, that somebody, oftentimes when people learn something new, that'll change behavior.
Okay, thank you.
Yeah. Ms. Powers?
The court wants to set a review in 30 to 60 days just to check in on the status of the evaluations. I know those can take a long period of time, but maybe it would be prudent to just kind of keep that tracking.
Yeah, Mr. Foley, any concerns if we were to set maybe a tracking date to just see progress on where those, if appointments have been set, at least, as a bare minimum, maybe within 30 days?
Yeah, no, I think that's good. And I think to have a little bit of leverage with Dr. Johnson would be a good thing. I'm not out to disparage him, we're friends, but I do know that he's known for the length of time it takes to get a report done. So to have some kind of leverage in the form of a review hearing, I think would be very helpful.
I would like a review just on July 16th at 9 a.m. if the parties are available to check status of all those evaluations, ensuring number one, that they've been made. And if not, why not? Because I think at that point of time, July 16th, appointments should have been made. And if some or not all of the evaluations, hopefully will be completed, with Dr. Johnson maybe being the exception. As far as preparation of today's order, Ms. Powers, would you be in a position to prepare that?
I can, yeah. Does the court want to set it on your presentation docket June 21st?
That presentation doc would be good. Let me check my calendar on the 21st because I think I'm absent. Yeah, I'll be in Seattle for a commission meeting. So we could look at the 28th would be one option. June.
That works. That would be fine for me.
Mr. Foley?
That's fine, Your Honor. I have two matters on the docket down here. So maybe if we could be moved to the end of the docket, that would be great.
So on that Friday docket, it's a pretty, I think there's only 3 cases that are allowed on for presentation docket. So
okay.
Expectation would be is 8:45 and hopefully done by 9.
Okay, that'll be fine.
Okay, Ms. Height, does that work okay for you?
Yes, Your Honor, thank you. And I believe it would probably be prudent for me. This was an odd orders appointing in that there was no date set for a final report. So it seems like without the information from all these evaluations, it's not going to be the best report we could come up with. So would it be prudent to just wait until we kind of get a possible date of Mr. Johnson, who will probably be the final one, Dr. Johnson's evaluation, and then set a final date somewhere in a scope of time there?
Maybe what we could do when we come back on July 16th, we could reevaluate that. And Ms. Height, if you'd remind the court to address that particular issue in choosing
Right.
a potential date for a final report.
That makes a lot of sense. Thank you, Your Honor.
Right, thank you. Right, if there's, so we have that date set for presentation. Everybody's good with the 28th at 8:45? I think that's right.
Yes.
Okay, great. So we'll see everybody then. Thanks everybody for your input and help.
Thank you.
Thank you, Your Honor.
23-3-00442-08. This is the Torres and Wolski matter.
Amy Powers here for Melissa Wolski.
Okay. And
Ann Height, guardian ad litem, Your Honor.
And I believe we have Luciano Torres.
Yes.
All right. Just a moment. All right, so this matter comes on in regard to request for contempt. And I just want to make sure that the items that that the parties want me to consider are in the Odyssey. The last document I have is from Mr. Torres that was filed on July 12th. So last Friday. And so I didn't know, Ms. Powers, if there's a responsive pleading or not.
I don't think a reply declaration is necessary. I would like to make a little bit of argument about it.
Okay. All right. So with that, counsel, go ahead.
Thank you, Your Honor. We're here on two matters today. One is our contempt motion, and the other is to review the status of evaluations that Mr. Torres was ordered to do from the guardian ad litem initial report. I'm going to start with the contempt order. Our office was forced to file a motion for contempt when Mr. Torres refused to return Ms. Wolski's personal property. Ms. Wolski moved out of the residence in September and has been trying to get her personal property since then. In November, the parties had a hearing, and the clerk notes reflect that the court ordered Ms. Wolski to work with Mr. Torres's attorney for the return of her items. She tried to do that and was unsuccessful. After she hired me, I reached out to Mr. Torres's attorney, Mr. Foley, and also tried to arrange exchange of the items. We provided list of personal property that Ms. Wolski wanted returned. Never in this process did Mr. Torres say that he did not have the items, and never in this process did Mr. Torres communicate to our office that he did not believe these items were Ms. Wolski's. Instead, we brought a motion on April 1st. Part of our motion included asking for return of her personal property. We included a copy of the list of items we were requesting. Mr. Torres, with help of counsel, Mr. Foley, filed a responsive pleading on April 25th, and in his response indicates he's set all of her property aside. He ended up agreeing to exchange it to her. The court entered an order on May 21st, 2024, indicating that the petitioner has set Ms. Wolski's personal property aside, and the parties will work together through their attorneys to arrange return of the items. I worked together with Mr. Foley, and we agreed for return of the items. On the appointed day, Mr. Foley delivered to my client a garbage bag full of things that were not on her list of items she wanted returned, along with an air freshener at the top of the bag that said "FU." That was all that was returned. I contacted Mr. Foley after this exchange happened and got no further response from him. To date, Mr. Torres has returned nothing on the list of property, and we're coming up on almost a year since the parties separated, and the items have not been returned to her. Mr. Torres did file a responsive declaration late last week. He did not serve our office with that response, but I found it in Odyssey this morning as I was preparing for this hearing. I would note that in his declaration, he indicates that he's now contesting whether any of the items are Ms. Wolski's, and he's now claiming that she got all of her items in September. I think that this is disingenuous when you look at the history that has occurred within the court system and the communications between attorneys that have occurred since September. At no point until this declaration filed last week has Mr. Torres claimed that Ms. Wolski already received her items. Instead, he's acted like he would cooperate and return them, although he has not done so. I'd ask the court to find Mr. Torres in contempt and order that he return the list of items by July 24th, set another review hearing for July 30th to follow up on whether or not those items were returned. If they're returned, that hearing can be stricken. I'd also ask Mr. Torres be ordered to pay $1,000 in attorney fees for having had to bring this motion, along with all of the communications I had to have with Mr. Foley, trying to get this resolved outside of court. Thank you.
Mr. Torres.
First, I would like to request a continuance as I did not completely file the declaration that I'd filed. I did not serve the opposing party, mainly due to finances preventing that from happening until this week. To respond to the statements made by Ms. Powers, my attorney did not communicate to you that the items were not here and that she had claimed them already. I did communicate this to my attorney. The items I agreed to provide were the only items that were left here. I told this to my attorney. My attorney has been acting without my input. He has been acting on his own, essentially, and is no longer my attorney and has essentially ghosted me. I've been requesting information from my case to him and has not been communicating with me. So I'm requesting a continuance so that I can continue to seek legal counsel and properly file this declaration.
Ms. Powers, in regard to that request?
I would ask the court deny a continuance. Mr. Torres was personally served on June 21st. That's more than the required time under the court rules. And he's had plenty of time to respond. And this is not a new issue. We brought this up in our motion on April 1st, which he responded to. It was brought up at a hearing in November. His response is new, but our requests are not new. Essentially, at this point, I think that he's just been stalling, and I don't think he intends to return any of these items, and I'm pretty concerned about that.
So at this point, I recognize that the matter has been pending, and I understand the concern as far as the idea of how long it is taking to get items and potentially what those items are. At the same time, the court always has concern on a contempt matter when a party is not represented, and if they are seeking an attorney, then the court doesn't have at this point, I'm going to grant the continuance. And that will allow proper service of getting that pleading to your office, understanding you did pull it off of Odyssey. So I'm going to give you a very short amount of time, Mr. Torres, because this has been pending for a while, as far as when it was served on you, as well as the length of time that these items are alleged to have been withheld or not returned. So I'm looking at August 6th.
I'm available that day.
Okay, August 13. Are you available then?
Yes.
Mr. Torres, are you available then?
I can be.
Okay.
And I am available on the 6th too. So either of those dates are fine for me.
Okay. Do you have a preference, Mr. Torres, the 6th or the 13th?
No.
Okay. So why don't we go ahead with the 6th? That'll give some time and as well as move it forward. So I'll set it to, so you are available, correct, Ms. Powers?
Yes, I am.
Okay, so we'll go ahead and set it over to August 6th. And Mr. Torres, just if you haven't been out seeking an attorney, get on top of that right away, because the matter will be going forward on that day.
I have a appointment scheduled for the 8th. Just remembered that. So would we be able to move it to the 13th?
Okay. If you have the 8th, then fine, we'll go ahead and set it to the 13th.
Thank you.
Could the court also set a date certain by which Mr. Torres has to file any additional pleadings? And I would ask to have at least a few days to reply in case that's needed.
So, Mr. Torres, there are rules that you do need to follow. I understand you're not an attorney. At the same time, there are rules that you need to follow in regard to the time of getting documents to the other party. And the Friday before is not an acceptable time frame. So you need to be aware of that. You need to look at the local rules and be familiar with those if you continue to represent yourself. And so with that, I would want you to, let's see, 8th. I would want, if you meet on the 8th, I would go ahead and have you file things by, let's see, we're on 13, 10, file things by the 9th. That'll give you a short time, Ms. Powers, but it still gives you time. So it's going to be a quick turnaround as far as the date. So I would get in and see whatever attorney as quickly as possible. Okay.
Good. And just to add to that, when I did call regarding the rules on filing and spoke with the clerk, they indicated that I just needed to file 5 days in advance, but didn't state that that was a hard rule. So my apologies for the filing.
Okay, the rules are the rules, and that doesn't sound, I don't know what they were looking at, but they don't give legal advice, so I'm not sure what you were being told. Anyhow, read the rules, okay?
Yes.
All right. All right, nothing further on that matter for today.
Your Honor, the second issue that was before the court was that Mr. Torres was supposed to give the court an update on where he is at with the evaluations he was ordered to complete.
I would just ask everything be set over to that same date.
Okay,
Thank you, Your Honor.
thank you.
Okay. Luciano Torres and Melissa Wolski is cause number 233442-08. We have Ms. Powers is present. She represents Melissa Wolski. Ms. Wolski, are you on the line today?
I see her name up there. I believe that she is.
Okay. All right. Looks like she's present. Ms. Height is here. She's the guardian ad litem. Welcome to you.
Good morning, Your Honor.
Good morning. And I'll ask if Luciano Torres is on the line. All right.
Yes.
Mr. Torres, I can see that it looks like you're on the line. Can you hear me?
Yes, I can hear you.
Okay, very good. Just so you're aware, your voice came across fairly faint. And so if you could just make sure your voice is extra loud when you're speaking, that'd be appreciated. Thank you.
Okay.
Much better. Appreciate that. All right, we're on today for Ms. Wolski's motion for contempt and also just an inquiry regarding evaluations of Mr. Torres. So I'll hear from Ms. Powers regarding your motion.
Thank you, Your Honor. We're here today on Ms. Wolski's motion to find Mr. Torres in contempt for failure to return her personal property. To give a quick history, the parties separated in September 2023. Ms. Wolski brought minimal amount of stuff with her. She was able to go to the home and get a few things, but not very much. She started asking for the rest of her personal property that fall, in the fall of 2023. There was a hearing on November 21st, 2023, when Ms. Wolski brought the issue of personal property up in front of the court. The clerk's notes indicate that Ms. Wolski was supposed to work with Mr. Torres's former attorney, Mr. Foley, to work together to get her personal property returned to her. She tried to do this with no success. Ms. Wolski hired me, and in March of 2024, I started communicating with Mr. Foley about return of her items. My first email to him was March 5th. Mr. Foley requested a final list of items she was requesting, and we provided that to him March 15th. We were unable to work out return of any of her personal property. On April 1st, Ms. Wolski filed a motion which included a request for return of her personal property. The motion had attached to it the list of items she was requesting. On April 25th, Mr. Torres, through his attorney, Mr. Foley, filed a response indicating that Mr. Torres had set aside the remainder of her requested property and would return it to her. On May 21st, 2024, the court entered an order that the parties would work together through their attorneys to arrange to return Ms. Wolski's things. Mr. Foley and I reached an agreement that the parties would return the items on May 22nd during the exchange of the child. On May 22nd, Mr. Torres returned 2 bags full of clothes that the kids had already outgrown. In the top of one bag was an air freshener strategically placed that said "FU." None of the items on the list that we had provided to Mr. Foley and to the court were included in the bag. Following this exchange, I reached out to Mr. Foley to arrange a new date. No response was received. Mr. Foley has now withdrawn from the case, and we've been forced to bring this motion. It's been over almost a year since Ms. Wolski moved out. A lot of her clothes and personal property were left in the home. She had a son from another relationship. Most of his things were still in the home. Ms. Wolski's brother passed away and left her some property that was also in Mr. Torres's home. None of these items have been returned to her. To date, Mr. Torres has filed a response, and at this point, he seems to be indicating that either there's no items left or he denies that any of these items belong to Ms. Wolski. Understandably, my client's really frustrated. She's been very proactive. We've taken a lot of steps to try to get her property returned to her. At this point, we're asking the court to fine Mr. Torres in contempt, order him to pay $1,000 in attorney fees for the cost of bringing this motion, and for all of the steps we've had to take in trying to get her property back. We'd ask the court to set a date certain that her property be returned, set a follow-up hearing to review compliance, and if Mr. Torres still won't comply, then at that point, we'll be asking that the court order a civil standby so that Ms. Wolski can go to the home and retrieve her items.
Thank you. And the list that you mentioned, that's in your June 20th motion for a show cause, that has the listing of the items.
Yes, and that's the same list that had been provided with our previous motion and also by email to Mr. Foley back in March.
Okay. All right. Thank you. All right, Mr. Torres.
Yes, as stated in my declaration, Melissa took all of her property when she came with her mother to pick up her items. She loaded her mother's SUV fully. It took her about an hour to load her property that she said she left here. She also loaded her own SUV that she took with her with property. So I don't know what property is left here. I've told my attorney this. I informed Mr. Foley this, that there was no property here to give. My attorney failed to communicate this to Melissa and her attorney. The items that are returned to her, including the air freshener, were the items that Melissa left here that belonged to her. This entire process began with me simply trying to establish parentage, and here we are a year later arguing over property that doesn't even exist. I've put in my declaration the times that she came, that she picked up items and was here doing things. I don't know. I wasn't even in the home. I was outside with my kids. So I don't know how she can claim that all this property is here now that she didn't have an opportunity to get when she came to my house repeatedly up until I filed my declaration for parentage, or my request for parentage. So I don't know what property is there to give.
Thanks, Mr. Torres. I wanted to ask you a question. In your response, you included some screenshots of, a video monitoring system at the home. And it looks like on September 5th, there were a time frame from 4:17 p.m. to 5:02 p.m. And are those images of Ms. Wolski and her mother, or just the mother?
That's an image of Miss Wolski entering and exiting the property with her items, her belongings, loading up her mother's truck. Her mother's truck is in the background by the tree, parked at the curb. Her mother waited in the vehicle while she loaded her car.
Okay. And besides that date on September 5th from 4:17 p.m. to 5:02 p.m., what other days did they come to the home?
Melissa came to the home. In the declaration, I don't know if you have it in front of you. I have the dates listed as well as the timestamps.
So I'm looking at your declaration that you filed on July 12th. And I see in the declaration itself, I don't see a listing of the dates. I see the security footage from September 5th with the
Should have been an email.
grabs. So on attachment B, date and timestamps when Melissa came to my home by herself after September 5th. So these are, tell me what this is. When I'm looking, it says September 18th, 1:40 p.m. arrives, 2:32 p.m. leaves. Is that something you typed out?
That is the timestamps of my security footage. I can provide video and screenshots if necessary, but those are the timestamps of when she arrived and the timestamp of when she left my property.
Okay, so you typed that out.
Correct. That is an email that I sent my attorney.
Okay, all right. And then I wanted to ask you one question regarding the bags, the 2 bags of clothing. Tell me about the 2 bags of clothing in the black bags.
That's what she left here at my home. I took everything out as I was told to photograph everything, and I put it in those bags, the black bag.
Okay. So you're telling me you don't have a 70-inch TCL TV in the living room?
I have a 70-inch TCL TV in my living room that I purchased for my home, and I notified my attorney that if she wants to claim that this is her property, she needs to show proof. I have receipts for the property.
So you have that in your home, correct?
That is in my home, yes. That it
And
belongs to me, yes.
a circle mirror from Mason's room, where's that?
That does not exist. She must have taken it.
Did you take any pictures after she came to your home on repeated occasions to document the property had been taken?
No,
You've been pretty careful to document when she came.
I might have some photos of the property when she came and took the stuff from the room, yes. I'll have to find that.
Did you submit those today?
No, I did not. I did not feel that I needed to, with the timestamps of her arriving and leaving, and as well as the timestamps of her taking her property and footage of her actually taking her property.
Well, when you look at the screenshots that you included in your declaration, let's just go to those. Show me where she's carrying property in those screenshots.
Would it be better for the court if I screenshotted an item in her hand?
I'm just asking you on the declaration and the photo submitted with the declaration.
Yes, the
Tell
photo
me where.
submitted, there may
So
be.
I'll go ahead and finish my question. Go ahead and tell me where in those photos she or her mother are carrying property.
I don't have the photos in front of me. Give me a moment to go get them.
Clerks indicate she's going to reset the FTR.
Okay, I have the photos in front of me.
Great, thank you. So I'm looking at your attachment A from your declaration. You can just guide me in the order that they were presented in that declaration of the pictures in which items are being carried, and then tell me what items are being carried.
So in attachment A, first, second, third, fourth. On the 5th page, there's an item being carried. Do I need to document every single item on her list of being carried out of my home?
I'm just asking you, just tell me what you see and tell me which items are being carried.
I don't know what items she carried. I didn't monitor everything that she went through in my house. From the look of the photo screenshot, it looks like a basket of items.
Okay, so you're on which photo are you looking at?
Going back, it's attachment A.
Mm-hmm.
And that's page 1, 2, 3, 4, page 5.
Okay, and so does it show where it says front door today, 4:55 p.m.?
4:53 p.m. It looks like Melissa's carrying some items out of my home to a black SUV that belongs to her mother.
So just make sure we're on the same photo. Top left corner of the picture says 4:34 p.m. and then down below that says 6:49.
Yes, the 4:34 timestamp is the screenshot for this declaration. The 6:49 is me recording the video footage, and the 5:50 or 4:53 p.m. is the actual timestamp of when the recording occurred.
So on that photo, there's multiple timestamps. There's 1, 2, 3, 4, 5. I'm looking at the very top one. It says 4:55 p.m. Is that the same one you're looking at?
Yes.
Okay. And that's a photo of whom?
That's a photo of Melissa and her mother when she came to pick up her items on the 5th. Loaded up the full truck, completely empty. Nobody, just her and her mother, loaded the full truck.
Where's the truck?
It's behind the tree, right there in front as she's walking towards it. It's under the shadow of the tree.
Oh, it's off to the right.
Yes.
Okay.
It's a Chevy Tahoe SUV.
Okay. And so there's that image. And then what other images indicate or show people carrying property out?
I did not know that I needed to include every single image of her carrying property, but if that was the case, then I would have done that. But I have multiple screen grabs that I can grab from the video. So if you continue down the list of screenshots that I provided, there's this third, two. If you go down 3 more pages, there's another photo of her carrying items to the truck. And the timestamp is 4:54. So that's a minute later, and she's still carrying items to this truck. 4:53, she's coming back to the door. 4:53, the door's open, so she's still loading the truck.
Okay, any other screen grabs in which property is being carried out?
I do not have any screen grabs in my declaration that have her carrying property. No, that's all that was submitted.
Okay. All right, thank you. And then you said there was a representation that you indicated with a declaration or a filing that as of April 25th, you had set property aside. Tell me just a little bit about that, how you ordered the property, where you put it when you set it aside.
What are you talking about? The 25th? There's an email, or what is it that you said? I'm sorry.
I'm not sure. I'll ask Ms. Powers if she recollects what happened on April 25th, where that information came from.
It was the declaration of Mr. Torres submitted through his attorney.
Okay, it looks like there's a declaration that you submitted where you indicated the declaration was dated the 25th of April, where you indicated you'd set the personal property aside.
Yes, I told my attorney that the property that was on the list either did not belong to Melissa or did not exist here. And he informed me that I should photograph the property and send it anyway. And I kept on getting multiple lists, which is why I requested a full list, a final list. And my attorney did not communicate that I contested the ownership of some of the property on the list, but the other stuff that's on the list does not exist here. And instead of communicating that, I received a declaration stating I will return the property that was left here, and which is what I did. A bag and the air freshener was what was left here.
Okay.
And so now I'm being held in contempt of court for doing what was requested of me by the courts.
Is the ice maker, it's still at the home?
I'm sorry, what?
The ice maker?
No.
Okay, air fryer?
Air fryer is still here, yes, but that was purchased for the home.
Okay, sewing machines?
No.
Tapestries?
I don't even know what that is.
You don't know what a tapestry is?
No.
Did you ask your attorney what that was?
He was not very communicative. In case you can't tell, he did not communicate with me very well. I don't even know what's going on with my case for the most part.
I was just asking a question. If you asked your attorney, if you asked him what a tapestry means, if you didn't know what it meant.
Why would I ask my attorney what a tapestry meant? That would charge me $175 for asking that question and wouldn't even answer it.
Well, one might assume that if one party in litigation is asking for a particular item of property and you've indicated that you've set property aside, you'd want to make sure that if they're asking for a particular item and you have it, then you could set it aside. So it seems reasonable that you might make an inquiry.
It seems more possible that my attorney would have responded when I said, hey, this stuff does not belong here, but that didn't happen. So.
Right, but you don't know what a tapestry is, so you wouldn't know if it was at your home or not at your home. That's why I asked the question.
Okay.
A dresser from Mason's room with gold hardware, is that in the home?
Yes, but that's what Mason uses when she's here. Is she no longer allowed to have things here at my home?
Okay.
Is everything going to be cleared out from my home because Melissa claims it's hers when it's not?
Wooden Christmas ornaments handmade from my grandfather in Christmas tree bag. Do you still have those?
I don't even know what those are, what they look like, which is what I told my attorney, and he didn't communicate that. This was back last year that we've been going through this.
Did you look in the Christmas tree bag to see if there were wooden Christmas ornaments in there?
Yes, I put up my Christmas tree when I looked and I didn't see it, which is what tells me that these things don't even exist here.
A silver laptop from the bedroom and a charger, is that in your home?
No.
Hunter's belongings? Any of
I
Hunter's
don't know.
belongings?
What do Hunter's belongings look like?
I'm just asking you the question, Mr. Torres. Do you have any of Hunter's belongings?
I'm asking you what they look like. I don't know what they are.
Mr. Torres, I'm asking you, do you have any of Hunter's belongings in your home?
How can I answer a question you just said? If I don't know what something is, how do I know if I have it?
A simple yes or no would suffice.
I don't know. If you could describe it, or if I come across something that doesn't appear mine, it may be Hunter's.
Is there kitchen decor on the walls? Is that still on your walls in your kitchen?
No.
Jackson's toys? Do you have any of those in your home?
Yes, but like I said, he's my son, and I still have another case that I'm willing to work on.
All right. Thank you, Mr. Torres, for answering my questions. Do you have any other information you'd like to share?
This completely is unbiased. This is biased. Like, that doesn't make any sense that she can claim property that doesn't even exist, and I'm being held in contempt of court for it.
Thank you. Ms. Powers?
Thank you. Just briefly in reply. First of all, Jackson is not Mr. Torres's child. That is Ms. Wolski's child from an earlier relationship.
Until a case is brought forth.
Mr. Torres, it's Ms. Powers' turn.
So all of Jackson's property should be returned to Ms. Wolski. As I've laid out for the court, Ms. Wolski began asking for her property as early as last fall. It was addressed in court in November. It was addressed with Mr. Foley directly with Ms. Wolski in the winter. It was addressed between me and Mr. Foley in March. It was addressed by motion in April. Mr. Torres, at that point in his declaration in April, agreed he had set aside the property. It wasn't until we get to July, after we filed for contempt, that Mr. Torres is finally saying he contests ownership of the property and doesn't have anything else to return. I think it's pretty clear that Mr. Torres is choosing not to return items, and we ask that he be found in contempt and that the property be returned to my client.
Thank you. Ms. Height, do you have any input?
Not on this matter, Your Honor. Thank you.
Thank you. Mr. Torres, it sounded like you had something that you wanted to share.
It doesn't matter. It's not going to make a difference.
I'll make a finding of contempt. There are three specific items on the list that Mr. Torres indicated that he has them and he's refusing to return them. In particular, Jackson's items, the air fryer and the dresser with the gold hardware. I'll impose $1,000 of attorney fees, a $100 civil contempt fine, and we'll set a review date to make sure that all the items in the list are returned. Today is the 13th of August. The 27th of August at 9 o'clock in the morning to make sure that those items have been turned over. If they haven't, then we'll set a date where we can have the police out there and go through the home and retrieve the items.
Your Honor, I'm
Yes,
sorry to interrupt. I'm not available on the 27th, but it may not be necessary for me to appear. I just wanted Your Honor to know that.
Thank you. Appreciate that. Ms. Powers, do you have any conflict with the 27th?
I don't have a conflict. I don't have a calendar in front of me. I would ask that this be in front of you for review. So I don't know whether you were putting this on the Tuesday docket or the Wednesday docket.
Yeah, if it's in front of me, it's going to be on the 28th. So Wednesday, the 28th at 9 a.m. Mr. Torres, are you available on the 28th of August at 9 a.m.?
No, I have my evaluation that I need to go take.
Who's that evaluation scheduled with?
Whatever doctor that was hard to get a hold of that you guys laughed about. I'm sure you remember, you and Foley were laughing. What was it? Dr. Johnson takes a long time to answer his phone and hard to get a hold of and schedule. Yeah, that guy.
Okay. So we'll set the review for September 4th at 9 a.m. Does that work for everybody?
That's fine.
Mr. Torres?
It's going to work for me regardless of whether or not I agree.
As I just indicated, there's flexibility. You said you weren't available on the 28th, so we made accommodations for you. So does September 4th work for you?
Yeah, that'll work.
Okay, we'll see everybody then.
Okay, and then I just ask that Mr. Torres contact our office to arrange return of the items prior to September 4th.
All right, Mr. Torres, you'll need to contact Ms. Powers' office no later than August 16th, 4 p.m. to arrange a date in which the property can be retrieved.
Okay.
And then Ms. Powers, as far as a presentation of that contempt.
But before we
order-
continue, I'm sorry to interrupt.
Go ahead.
Who's going to pick up the property and where is it going to be exchanged? I want to address that now in front of the court.
Yeah, that would be one item that the parties could work out when discussing it over the phone, but if
Okay,
you want to
that's
do
fine. We
that-
can work it out.
Okay. Okay, sounds good. Then as far as presentation of the contempt order from today's ruling, we generally set those for Fridays. Or actually, we can set it for a Wednesday, probably. Wednesday at 9 a.m. is probably a better date and time. Although Friday at 8:45 is an option. Any preference, Ms. Powers or Mr. Torres?
I have no preference.
Okay, Mr. Torres, any preference?
No.
Okay. Let's set the presentation for let's see, let me just double check one date.
I believe I have another matter in front of you on the pro se docket on August 21st. If we could we just put it there?
Okay. So we're looking at setting a date for the presentation of the contempt order, basically a summary of what happened here today. Ms. Powers would draft that. She would send a copy to Mr. Torres. Mr. Torres, if you feel that she accurately reflects what the court ordered here today, you could sign off on it and submit it to the court for signature. If you feel that she has gotten it wrong in some way, then we'd be here on the 21st and you could express your disagreement and we can sort that out. So August 21st at 9 o'clock, are you available, Mr. Torres?
August 21st at 9 o'clock. Let me take a look.
Thanks.
Yeah, I can be available on the 21st at 9 o'clock. I'll have to move around some meetings, but it should be fine.
That's great. Thank you. We'll see everybody on the 21st at 9 a.m. for the presentation, and then we'll have the review on the 4th of September at 9 a.m. And then the review, the deadline for Mr. Torres to contact Ms. Powers' office will be this Friday prior to 4 p.m. Thanks,
Thank you,
everybody.
Your Honor.
That'll conclude the matter.
Before we conclude the matter, this was actually on for two other things. We were supposed to review the GAL reimbursement and also review Mr. Torres's compliance with the 3 evaluations he was ordered to complete.
Okay. Ms. Height, do you want to address the reimbursement? Any information you care to share?
I am still waiting for $2,200 of payment. He's made a partial payment, and we had an agreement, and then he had some other expenses come up, and he has not yet been able to pay. I've been in contact with him, but haven't heard anything specifically back. Along with that, I have used my hours, but we don't have any final dates for this particular case, so I won't be able to complete it until he has completed his evaluations and I've heard back from the evaluators. So while I want to be paid correctly, I could certainly allow some time for that to happen.
Yeah, with the evaluations, and that might take a little
Right.
bit longer, right?
Yeah, I think having a deadline would be good, but it doesn't have to be like within the next 10 days or anything.
Okay. And so you indicated $2,200 is outstanding
Correct.
from both parties or just one?
Just from Mr. Torres.
Okay. All right. Thank you. Mr. Torres, any updates as far as the GAL fee?
I sent her an email and we'll be working out some kind of payment, I believe. I'm having to save up money to do the evaluations first, since those are court ordered and those are what are preventing me from seeing my children.
Okay. Have you paid all those evaluations at this point?
No,
Which ones have you paid?
none.
Okay. And what's your plan as far as paying the GAL fee?
I plan to make a payment monthly until it's paid down.
Okay. And did you and Ms. Height talk about that arrangement?
I sent an email, but I don't believe I received a response confirming it, so I'll need to confirm with her.
Yeah, I have not received any email about payments.
When did you send it, Mr. Torres?
I believe it would have been a few days ago. Basically, I was stating that I can commit to paying $100 a month until these evaluations are done, but my priority is going to be for paying these evaluations since that's what's preventing me from seeing my kids.
Okay. If you want to take a moment right now and go into your sent email and just go ahead and forward that to Ms. Height, I'll wait and we'll make sure Ms. Height gets that.
Okay.
We've been able to locate the email, Mr. Torres.
Yes, I'm just signing into my email right now. Looking for it now. It was sent August 8th. I'm re-forwarding it now. It's sent.
Thank you, Mr. Torres.
Your Honor, could Mr. Torres give us an update on where he's at with the DV evaluation, the SUD eval? And then in terms of Dr. Johnson's psychosexual evaluation, Dr. Johnson has contacted our office and we've provided him copies of pleadings from the case.
Okay. Thanks. Mr. Torres, update. It sounds like you said that you have your appointment with Dr. Johnson on the 28th of August. Is that accurate?
That is correct.
Okay.
Assuming I can pay the fee for the evaluation.
Okay. And where do you stand with the domestic violence and the substance use disorder evaluations?
Substance use disorder has been completed. I believe Anne stated that there was no treatment recommended, but more to come on the report or something. And then the domestic violence, it's been a phone tag with them, so I'll need to probably just show up in person to make an appointment. A lot of these places don't seem to answer their phone for some reason.
Okay. When did you complete the SUD evaluation?
I don't remember the exact date, probably the 7th or something, maybe.
Of this month?
Let me see. I have it in email to Anne. Let me sign in again. It was, I don't remember the exact date, but it was a few days, I think, after the end of the month.
Your Honor,
Yes, Ms. Height.
I have a copy of Callett's Family Health document about his SUD, which they state was completed on July 25th.
25th, there you go.
But there was no collateral information. Their report is based solely on patient report. So I notified Ms. Wolski that she needs to participate. I don't know if that's been done. So I have an initial report that was completed, but we just need another piece to put in that.
Thanks. Ms. Powers, do you know if your client had provided any collateral input into that evaluation?
I don't know, and I wasn't given any notice that an evaluation had been done or completed. I'd ask that the results be sent to my office as well. And I will ask Ms. Wolski to contact the evaluator to provide her collateral contact.
Okay. Mr. Torres, would you be in a position to forward the report from the evaluative report from a family health center to the guardian ad litem and also Ms. Powers?
I never received the report.
Will you obtain that report and then forward that to the guardian ad litem and to Ms. Powers?
Will they release it to me? They didn't release the drug screening results to me.
It's
Even
your
though I paid for it.
evaluation. I think you can request it, and then if you need to sign any releases, you can sign those, and then you can obtain those and then forward it to the guardian ad litem and Ms. Powers.
I'll make a request and see if they give it to me.
I'll set a deadline and it'll be received by Ms. Height and Ms. Powers no later than August
What was
20th.
the reason for signing the release of information?
I'm just saying that may be one of their requirements. I don't know if that's the case or not.
Well, so now I have to go follow through and provide Amy and Anne with the documentation that they were given rights to request themselves.
That's correct.
Why? Why can't they request it? Why am I having to be the one to request it for them?
It's your report. You're in the best position to request that with minimal effort.
That's not the case with the drug screening, is what I was saying. But they have an actual release form for the information. So now I have to take time out of my day
That's
go
correct.
request
You
this
do.
form.
That's correct.
Okay.
August 23rd, need to be in the hands of Ms. Height and Ms. Powers.
Okay.
And just be aware that if there's not collateral input on the evaluation, it may need to be redone. Just a heads up on that.
So I just continually be charged for these evaluations until somebody decides it's enough is enough.
Just a heads up, Mr. Torres, that if there's not collateral input on the evaluation, you may have to redo it.
So essentially, I can continue to be charged for this indefinitely, is what you're saying.
Just giving you a heads up, when evaluations are done, self-reporting is important, and having a broader picture through collateral input generally fills in more of the picture and is generally more reliable. So as a result, the domestic violence evaluation, the SUD evaluation, all require collateral input.
So then why doesn't she provide the collateral input first so that when I get there, it's already there?
When Dr. Johnson completes his report, you'll need to supply a copy of that to Ms. Powers and also Ms. Height.
Okay.
Any other items, Ms. Powers?
No, I would just point out that the order entered by the court on June 28th, 2024, that requires each of these evaluations specifies that each evaluation must have collateral input from both Ms. Wolski and also from the guardian ad litem.
So why not have her submit that before I go?
Does that sound familiar to Mr. Wolski, that the court ordered on June 28th that you have to undergo an SUD evaluation with collateral input from not only Ms. Wolski, but the guardian ad litem?
It's Mr. Torres, not Mr. Walski.
Pardon my error, Mr. Torres.
Thank you.
Do you want to answer my question now?
What was your question? I was thrown off by the error of...
June 28th, you were ordered to undergo an SUD evaluation with collateral input from Ms. Wolski and the guardian ad litem. Do you recall that?
Yes.
And did you inform the evaluator of that requirement?
Yeah, I did, which is why I signed a release of information form so that Amy and Anne could get that information.
Okay. So the same guidance that I indicated before, that if the SUD evaluation does not include collateral input, it may need to be redone. Needs to be redone.
Cool. So I'll just basically wait until the collateral input is submitted then, or what should I do?
You figure it out, Mr. Torres. You're an intelligent man and you like to argue, so you figure it out yourself and comply with the court order.
Great.
Okay. Anything else, Ms. Powers?
Nothing further, Your Honor.
Ms. Height?
No, Your Honor, thank you.
Mr. Torres, anything else?
I'll figure it out.
Good for you. Take care.
You too.
Thank you.
What date are we coming back on that? What's the first date?
We are coming back for presentation August 21st at 9 a.m.
Just gonna put a little note to myself. All right, next let's take up the Luciano Torres and Melissa Wolski matter. We have Ms. Powers present. Ms. Height is present as the guardian ad litem. Mr. Torres, are you on the line? So, Mr. Torres, I think you're on the call, but I'm not hearing you. I think he was admitted under the phone number ending in 0197.
I see him listed.
Oh yeah, I see him also. Yeah, there's his name. So, Mr. Torres, it looks like you're muted.
Hello.
Are you there, Mr. Torres?
Yeah, sorry, I'm having internet connectivity issues today. It seems to be dropping the Zoom meeting for some reason, but are you able to hear me now?
Okay, great. Very good. Thank you. We're here today for presentation from the order that was entered verbally at our last hearing. I have a proposed order that's been prepared by Ms. Wolski, by Ms. Wolski via Ms. Powers. Mr. Torres, did you receive a copy of that proposed order?
Yes, I did.
All right. Do you have any objections to that order as being representative of what the court ordered on that at that hearing?
Yes, I do.
Okay, go ahead and tell me what those are.
Page 3, section 11, it states returns the items on the list filled as exhibit E. Looking at the hearing minutes from the 13th, it states I'm to return 3 items specifically.
So you're referring to the hearing that was on August 13th, and you're making reference to the clerk's minutes?
Yes.
Okay, and then tell me which page you're looking at and where on the page, roughly middle, top, bottom.
I don't have the minutes in front of me, but I can give you the verbiage. I believe it said court rulings finds items to be returned. I believe it was the dresser,
The air fryer,
yes.
and it says Jackson's items. So it says three specific court finds petitioner in contempt. Three specific items are to be returned to Ms. Wolski, including Jackson's items, air fryer, and dresser with gold hardware. Okay, so that's in reference to the proposed contempt order, paragraph 11, that makes reference to the June 20th attachment E.
Your Honor, could you give some more clarification on this? Because during the hearing, the court was going through the list asking Mr. Torres if he had these items. There were several items that the court came to that Mr. Torres indicated he didn't even know what the item was. My understanding of your ruling is that he was to return every item that he still had on this list. The court had just found specifically that he had these three items and agreed they were Miss Wolski's, but that there were potentially additional items on this list that he still had because the court didn't talk through the entire list with Mr. Torres. Mr. Torres has contacted our office and we've arranged for return of the items to Miss Wolski this Saturday at noon. In communicating with Mr. Torres, he will only confirm that he will have the dresser available for Ms. Wolski to pick up, not any of the other items on the list. So I know we've got a review hearing set after the items are exchanged, but it would be very helpful if the court would be clear about what they expect Mr. Torres to return to purge this contempt.
Okay. Thanks. I appreciate both parties' input. So the clerk's minutes that reference the three specific items, those are the three items that serve as the basis or the foundation of the finding of contempt. So there is a contempt motion brought for non-return of items. There are at least three specific items that form the basis of the finding of contempt. I do find that the attachment E, all those items should be returned. So that should be clear that all those items are to be expected to be returned when the parties make that exchange. Any other objections to that proposed order, Mr. Torres?
No.
All right, I will sign off on that. And we will have the next review on September 4th at 9 a.m.
Thank you.
Thank you. Ms. Height, any comments from you?
No, thank you, Your Honor.
All right, very good. That'll conclude the hearing. Thank you.